Item number 50, item number 50.
Yes.
I have got the respondent. Our objection is that, but because of disruption of communication,
What?
disruption of communication with a Oracle, the opponent could not come.
We'll see when the matter reaches. Next.
Recommended for listing one high lot in testament appeal for withdrawal lot. Tomorrow lot.
What tomorrow? What tomorrow? We'll have it on Friday.
Friday. Much of like lot. Pilot I expect target for it. In your context out of season tackle I got referee go back.
Item number?
3.
Yes, what is it?
But you know that out of the season Megala High Court for referee go back. That's what it
At the request of the learned counsel for the petitioner, matters can be adjourned to be listed up to 4 weeks.
May please lordship, I back to the item number 14 of the dated is lordship English counsel for petitioner Mr. J. Pine is not available today, so lordship may this matter may come on another day.
The request of the learned counsel for the appellant matters can be adjourned to be listed up to 4 weeks.
Your Lordship, I beg to mention RSA 41 of 12 for withdrawal. The matter has been settled. The matter has amicably settled by the
Friday.
Please, Your Lordship. In item number 24, I have instruction to withdraw it.
Item number?
24.
There is a stay. Make the mention at the time when the matter reaches, because then we have to pass a consequential order. Yes, the payment has been made.
Yes, okay.
You got the payment, Mr. Jain?
Lordship, they have paid one amount, but 50,000 which was disputed. 50,000 of the amount of the total amount was disputed on the last day. They were asked to obtain certificate. They could not obtain certificate. They want 15 days time. Further, because further inquiry is going on. They want that within 15 days, if not found, they will deposit with it.
So they have deposited how much?
And they deposited 4,79,534 as per the draft.
They deposited 4,79,353.
Yes, sir.
It has been submitted by the learned counsel appearing on behalf of the petitioner that the amount of rupees 4,79,353 have already been paid to the petitioner.
No, it has been deposited. I have not.
Where?
Been
You have deposited.
Before rest.
Have already been deposited before the Register General Guwahati High Court on 6/5/2024.
8/5.
Huh?
8/5. I have deposited 8/5/20.
On 8/5/2024. In that regard, the learned counsel appearing on behalf of the respondent have placed before this court a communication issued to the Register General Guwahati High Court on 6/5/2024. Same is kept on record and marked with the letter Y. Oh, no, like it is seen from the office note dated 8/5/2024, which is kept on record and marked with the letter X, that an amount of rupees 4,79,353 have already been deposited by a demand draft number 679461, dated 6/5/2024. The petitioner herein would be at liberty to file appropriate application before the registry for release of the said amount. The registry shall, upon proper verification, release the said amount to the petitioner. It has also been submitted by the learned counsels appearing on behalf of both the parties that as regards the dispute of 50,000, which was duly mentioned in the order dated 29/4/2024, the authorities of the respondents are reconciling their account as to whether the said amount has been duly deposited, paid or to the petitioner or not. It has also been submitted that this reconciliation shall require a further period of 15 days. Accordingly, let this matter be listed again on 31st of May 2024, on which date an update will be given to this court as regards the remaining amount of 50,000.
Yeah, that's it.
You sort it out amongst yourselves. Yes, madam. Thank you. What is this?
My lord,
Oh, that thing.
Yes.
Information. Yes, what has happened?
the date of the date is 25/4/2023, my lord. And these are the names of the legal years, my lord.
You give it to him. Mr. M.K. Sharma, the learned counsel, who was earlier representing the sole respondent, upon being requested by this court by the order dated 30/4/2024, has informed this court that the respondent expired on
25/4/2023.
25/4/2023. 25/4.
25.
2023. He has also furnished the details of the legal representative of the respondent
Yes.
to the learned counsel appearing on behalf of the appellant. List the matter after 2 months.
Obliged.
Yes, why is it to come up for motion? It should have come up for admission. I have already issued notice.
Lordship, I pray for 2 weeks time for filing affidavit.
Filing what?
Affidavit one.
Why?
affidavit. Because the few dates are what it was in trial court is not coming up in the CRP.
This court, by an order dated 4/4/2024, had already issued notice, and as such, the matter ought to have been listed for admission. Mr.
P. Goswami.
P. Goswami, the learned counsel appearing on behalf of the respondent, submits that he wants to file a short affidavit to bring on record certain documents. Okay. List the matter again on 27th of May. Possible?
File of June would be
Okay.
better.
List the matter again on 3rd of June 2024. The interim order passed earlier shall continue till the next date. In the meantime, the respondent shall file their necessary pleadings.
Okay.
Yes, Mr. Mozumdar, what do you say about that thing in this case? Whether it will be the entire exclusion or only the night?
For remaining period, entire, not 90.
Just
Because that is what seems to be the reading. That after the period, during the period,
Minor.
during this period, the limitation expires, you get a further period of 90 days.
90 days, or if there is more than 90 days, then the larger period. So in our case, it was larger, 272 days. Even after calculating 270 days, there is a delay of 16. We have not taken 90 days, entire period we have.
My lord, the petitioner, myself, and the learned judge below all are in line with the interpretation of that Supreme Court order.
None appears on behalf of the petitioner on call. List the matter of the two witnesses. Yes,
That respondent as a plaintiff, I can reject I am a tenant under the respondent. Now, at the time of filing of the case, they have filed some invoices of the computerized copy without filing any certificate as required under section 65B of the Evidence Act to show the sources and authentication of the document. I have also raised pleaded that no certificate is required in by has been filed in by WSA. But thereafter, they have filed, my lord, the evidence. In the evidence, my lord, at page 24, your lordship may come, where they have stated that no certificate is required. At page 24, paragraph 50, that it is a fact the invoices had continuously been issued to the defendant. Of course, such invoices, no certificate is required as claimed by the defendant. So thereafter, I have filed an application under Order 13, Rule 3 for rejection of these money exhibits, because these are not money admissible under the law. So when I have filed this application, they have filed an application, another application under section 151 of the CPC to allow them to file the certificate marked as exhibit 64. So I have filed my objection that when there is a specific provision under Order 7, Rule 14 to take the leave, the application filed under section 151 is not mentally. In as much as that petition under Order 7, Rule 14 could be filed before filing the evidence on affidavit, because these are specific provisions of Order 7, Rule 14 that without taking the leave from the court, no evidence can be, no document shall be taken in evidence. I am reading my order. It's Order 7, Rule 14, Sub Rule 3. A document which ought to be produced in court by the plaintiff when the plaintiff is presented to be entered in the list to be added or annexed to the plaintiff, but is not produced, entered accordingly, shall not without the leave of the court be received in evidence. So without taking the leave, they have filed their evidence, or in the evidence they have stated that no certificate is required. But subsequently, when I
evidence is over.
No, my lord, my cross-examination, I did not cross-examine, and I filed that application for rejection of this exhibit for which no certificate is filed. So this was kept in abeyance, the main suit, and the hearing was taken up on these two applications, one filed by me, another filed by the to grant the leave. So my
Here the court has granted the leave.
court has granted the leave.
So,
Court has granted the leave, but on the
so
only
Mr.
on,
Sansidi, what do you want to do?
no,
Withdraw or dismiss?
I shall withdraw, my lord, but
Fantastic.
certain things, my lord, but I would like to state that when there is a specific provisions of law, my lord, case could come under the specific provisions of law, my lord.
Mr. Sansidi, if I keep this matter till July, it will become infructuous.
If
It
you are
is
not-
coming into account of that new act, more particularly the new evidence act, this document can automatically come up. Problem.
then I shall
Mr. See, the thing is like this, let the court decide on the admissibility of the documents at the time of the trial, appreciate it at that time.
but my petition was rejected. My petition was rejected.
Understood. You wanted the rejection of those documents under Order 13 Rule 3.
Oh, yes.
Order 13 Rule 3, you wanted that rejection.
Yes.
The court may not do so. The court, normally, if you see, there is one judgment of the Supreme Court which makes it clear that these objections should not be decided immediately, then should be decided at the time of delivering of the judgment, or appreciating that evidence at the time of delivery of the judgment. Because if they do it now, then an appeal is filed. Then under Order 41 Rule 27, that document is given. Then it will be a case of remand again. That is what the Supreme Court said. So it is under such circumstances, it should not be done. So you have in the statute book, Order 13 Rule 3, but Order 13 Rule 3 says about rejection of those documents should not be given or should not be allowed to be exhibited to the effect.
Yes.
Yes, but it should be, but it is on the question of relevancy.
Right.
The court may at any stage of the suit reject any document which is considered irrelevant or otherwise inadmissible, recording the grounds of such rejection. The Supreme Court says that you don't do it now, later on. Mr. R.C. Sansiti, the learned counsel appearing on behalf of the appellant, petitioner submits that he would not like to press the instant proceeding, challenging the order dated 8/1/2024 passed in Ms. J case number 598/2022 and Ms. J case number 435/2021, arising out of title suit number 302/2018, passed by the learned court of the Civil Junior Division number 3, Kamrup Metro at Guwahati. He, however, submits that the instant order should not preclude the petitioner to put objections to the documents at the time of cross-examination. And the learned trial court to decide the admissibility of the document at that relevant point of time, at the relevant point. So taking into account the above, the instant petition stands closed on withdrawal. The withdrawal of the instant petition, the instant proceedings shall not preclude the petitioner to put objection to the documents, more particularly Exhibit 3 to Exhibit 42, as well as, and also request the trial court to decide the admissibility of those documents at the trial of the suit. At the time of appreciation of the Yes, what is it?
But I think for lordship, my lord, against an order at page 47.
Page
47.
Yes.
My lord,
In disposal of the case, the custody of the child has to be with the mother. The grandparents shall therefore hand over the custody of the child to her mother of the deceased mother has only a legal right that is a basic event. Then what is wrong with that?
My lord, for my lord, two counts, my lord. My lord.
Who are you?
I am the grandparent, my lord.
Why? What right do you have?
My lord, the child, my lord,
Child is what is the age of the child?
6 years.
6 years. Then
My lord, he is residing with me at Dimapur. My lord, he is sitting at Dimapur. My lord. Section 9, my lord, of the Jurisdictional Ward Act specifies that the jurisdiction is the court where the child ordinarily resides. My lord. There is one aspect, my lord, because it's an admitted position, my lord. In
where
the
is the filing? Karbiangalam, nearby. No
Karbi-
problem.
Long, my lord. So, my lord, in page 19, she has admitted, my lord, that the child.
You want? I should issue notice. I will, but I will say that this order needs to be complied.
But, my lord,
No, nothing.
but
Absolutely no.
My lord,
Whatever may be, the mother is the legal guardian.
my lord,
The
mother is the legal-
grandparents have no business
but, my
out.
lord, the judgment, section 17 is very important, my lord.
I
Because
am not going to look into any
Because-
section 70 or nothing. Mr. Counsel, nothing.
because
I am making it very clear to you that this proceeding, I am not going to stay this proceeding. On the other hand, directing this compliance. Why the mother should not have the custody of the child?
my lord, what has happened, my lord? 2022, he left from Dimapur, my lord. 2022, when the child was around 3.5 years. And thereafter, the father of that child, my lord, died, my lord, after 3 months of their marriage. So thereafter, he did not turn back, my lord, to Dimapur, my lord. Everything, whatever has been done, that's done by the grandparents, my lord. And she is there with the grandparents of since 3.5 years, my lord. I have annexed a copy of the, my lord, school certificate and everything, my lord, that he is studying there now. So, my lord, at this stage, my lord, what the judgment of the effect court says, my lord, whenever the custody of the child has to be given to any other person, my lord, first of all, the court is looking
Not any other person.
Eh?
There is no any other person, the mother.
Yes, mother. Even though, my lord, it has been stated, my lord, I will place one judgment, my lord. There are two judgment, my lord. I will just place, my lord, regarding jurisdictions, my lord. Because ordinary deciding is very important, my lord, because it has been decided by the apex court in Ruchi Majo case, my lord, and that has been reiterated, my lord, in the case of, my lord, Lordship may kindly see, my lord. The similar issue that has been raised before, my lord, recently, my lord, in the High Court of Madhya Pradesh, reiterating the judgment of the Ruchi Majo, my lord, this judgment has been delivered, my lord. Lordship may kindly see, my lord. So, my lord, the first judgment, my lord, I'll just take Lordship to page para 8, my lord. Para 8, my lord. How the ordinary side system determined, my lord.
Yes.
Lord, if the Lordship sees, my Lord, that the judgment of the Madhya Pradesh, my Lord, dictating that, my Lord, that there are eight, my Lord, is very much clear, my Lord.
No, come to the Supreme Court.
Yes, my
Supreme
Lord,
Court
Supreme Court,
first was the Delhi High Court judgment, which was set aside, where the Delhi High Court says that the child is residing at America, so it should be at America. The Supreme Court said nothing to it.
my Lord, may kindly see that.
I am, whatever may be, you want to go to Supreme Court, go to Supreme Court. But I am telling you, I am not going to touch on this aspect of the matter, take on the question of jurisdiction or others. When the father is not there, the mother is the legal guardian out there, the mother has a right to take the child.
But the children of the child, my Lord, is in the 30 kg, my Lord.
So what?
My Lord,
The mother
in this
knows,
case, my Lord,
the
unless
mother knows the benefit. You are not, the other people can't say anything.
my Lord, welfare for section 13 has to be looked into, my Lord. If Lordship is there, this provision
I
7,
am
my
not
Lord,
going to state.
provision
And what happened on 5-4?
5-4, my Lord, there was, my Lord, I have stated, my Lord, in my petition, my Lord. On 5-4, my Lord, it was fixed for necessary order on 26th. On that day, there was an election, my Lord. So ultimately, the case was posted on.
So you have not
25.
complied with this order also.
No, my Lord, on my Lord, this on.
You want a notice, I can issue a notice, nothing more. But I'm going to say that the order needs to be completed. Mother knows the benefit of the child. After all, the mother is the legal guardian. I do understood. If the father is there, it's okay. Father is not there. Mother is the only there. Mother would always do for the benefit of the child. And you are excluding the mother? Don't go into the technicalities of all these things. I'm not on the.
Even not a jurisdictional.
Forget about the welfare. The welfare is best
Yes.
thought about by the mother. What is your allegation against the mother?
No, my Lord, actually, my Lord, she left, my Lord, she doesn't come back, my Lord.
She wants the child.
My Lord, what has happened, my Lord, is not that there was some dispute, nothing as such, my Lord. She left Dimapur, my Lord, she went to Tipu, and thereafter she has not turned back, my Lord.
So
Even
she now wants to come back, not come back. She wants to take the child and stay at Tipu.
So what I have submitted.
Tipu also has good Don Bosco schools.
What I am submitting, my Lord, before taking into consideration.
We'll ask the district judge out there, Karbianglo, to arrange a school, a seat out there in Don Bosco. You okay? If you think about the welfare of the child,
The court is to take it first.
that is what. Am I not a court?
Yes.
Then I'm not going to go into these technicalities as regards jurisdiction. After all, it's the mother. If she had filed it in Guwahati also, I would have allowed. Is it conceivable? The mother is the natural guardian. Unless you have serious allegations against her that she has some problems with that, she's a drug addict or something to that effect, and she is not capable of looking after the child, why will this court at all interfere with all these types of orders? What do you want? A notice with a direction or the dismissal? Either of it. Dismissal helps you to go to Supreme Court. Dismissal. Either of it. Like the earlier matter, I gave Mr. Sancheti the two options. Withdraw, dismiss. Here is withdraw or no withdraw. Dismiss or notice with a direction that this order needs to be complied, asking the police also to make it compliant. So try to amicably settle to do whatever may be with the guy. Can the grandfather and the grandmother say that, okay, the mother out there shall have no right? That, don't come up with all these technical objections out there. Where ordinarily resides. Tomorrow, if a child is being just taken away, it is more of a case, the child is being taken away. And the child is residing somewhere for 1 year and they have not been, a mother comes to know, oh, look here, I come to know that this person has kept it. Then the mother has to go there and not in the place. You are okay if the matter is transferred to Dimapur. We transfer the matter to Dimapur, but the child has to be given to the mother. Exercise 227, 24 and all. You transfer it there. Then fight it out there, but now give the child to the mother.
If you go by my lord, the judgment of my lord,
Judgments of the Supreme Court,
not better, right?
issue it there. I'm dismissing it then. Keep the mother left. When is the next date?
Right.
Huh?
17.
17/5. Now, you should notice making it returnable on (22/5/2024). The petitioner herein is directed to take steps upon the respondent by way of dusty, routed through the registry of this court and file an affidavit of service on or before the next date. It has been informed by Mr. A. Alam, G. Alam, the learned counsel appearing on behalf of the petitioner, that the next date fixed in in Miji case number 02/2023 is on 17/5/2024. The Court of the District Judge Karbi Anglong is directed to decide the question of territorial jurisdiction on that date and on or before the next date so fixed. It is on 24th. Let's have it on 24th, 24/5. To decide the said question of jurisdiction on or before the next date. To pass necessary orders on the point of jurisdiction on or before the next date fixed by this court, that is on 24/5/2024. A certified copy of the instant order is placed before the learned district judge Karbi Anglong for doing the needful. The registry shall also intimate the learned district judge Karbi Anglong about the instant order forthwith. No stay. It's be on the Yes, Mr. Mukherjee.
The impugned order is at page 86, Your Lordship, whereby my counterclaim has been excluded. Your Lordship.
Huh?
My counterclaim has been excluded by the court.
Why?
Because in the plaint, Your Lordship, there are three schedules. Schedule B and Schedule C are my land, admittedly in the plaint. And in my counterclaim, I have alleged that they have encroached my Schedule B and Schedule C land, and I have raised counterclaim in respect to those lands. And since there are two counterclaims because of two schedules, the court says that in view of there are two separate counterclaims in the same suit, there may be a difficulty in deciding the matter. As such, there was no objection from the plaintiff side as mandated by Order 8, Rule 6C that counterclaim can be excluded only upon an objection by the plaintiff. There was
Where is the Supreme Court judgment? What? Don't come unprepared before this court. The Supreme Court says it can be permitted. The Supreme Court has categorically mentioned that counterclaim may not be only restricted to that matter which is there in the plain. Can go beyond that also, but it has to be between the same parties.
This case, it is exactly the same.
No, therefore, we can dispose it off. No? Why should we issue notice? We can direct the heir to consider, review this order in view of that. Take into.
There is no legal part that there cannot be two counterclaims.
And there's two counterclaims.
Yes, because there are, in the plain, there are three schedules. Schedule A is admittedly government land. The plaintiff claims that they are occupants of government land, which is adjacent to two patta land, one of defendant number 1 and 2, another of defendant number 3, adjacent to two patta land. And this defendant number 1 and 2 has set up one counterclaim, stating this patta land to be theirs, and the plaintiff has enforced upon that. And similarly, defendant number 3, who is occupier of the owner of another patta land.
No, another means you can't bring anybody else.
Not anybody, same part.
Hmm.
Lordship, the plain is that annexure 1. Page
Eh?
12 onwards, the plain starts. Defendant number 1 and 2, Mukul Burman and Arati Burman, has filed a written statement along with a counterclaim. And defendant number 3, Suchitra Burman, has filed a separate counterclaim, a separate written statement. And the land claimed by this defendant number 1 and 2, page 25 of the plain, page 25 of my petition, internal page 14 of the plain, schedule B of the plain, exactly reflects the same. Yes.
Because otherwise this will lead to another suit.
Otherwise,
So that is the basic reason you need not file it.
Lordship may peruse page 25 to clarify.
Page?
25. Page 25 is the B schedule, schedule B of the plain. It's the plain schedule B. It corresponds exactly to schedule of my counterclaim, which is at page.
You are who?
I
Defendant
am
number 1.
defendant number 1 and 2, 1, 2, and 3. All are before your lord.
1, 2, and 3. 1 and 2 has submitted
A separate WS with a counter.
and 3 has submitted a separate one.
All are excluded. So this page 25 exactly corresponds to page 55, which is schedule Y of the counterclaim.
Yeah. This is
And
the counterclaim.
this is one of the counterclaims.
Then the other one,
Page 26 is the schedule C of the plain, which exactly corresponds to page 83. Page 26.
schedule
Page 26 is schedule C of the plain.
C.
C. It exactly corresponds to schedule X, page 83 of the document. And in schedule C also, it is admitted in the bracket land of defendant number 3. Schedule B and C, the plain. They are admitting it the land of defendant number 1 and
No, there is a judgment of the Supreme Court. Find it out. We'll take it up. We'll dispose it off. Huh?
regarding exclusion of
No, it says these two counterclaims is of the same property itself.
same property.
Then
there's a judgment to the effect that even if it's beyond the
Beyond that also
can
it
be
can be.
considered.
Because this will only stay the proceedings. Now you bring the judgment, then I will say that you place it before the and to reconsider this order. I think that is better, because without the other side being there, to pass an order would not be proper. So in view of this, I will direct the heir to reconsider in view of that. Then I think your problem is solved. Yes. What are you challenging?
An order, my lord, whereby the original plaintiff wants their name to be struck off, they want someone else to be replaced.
Hmm.
The suit, my lord, I am the defendant tenant. The suit is between landlord and tenant. And it was originally brought of the twin grounds of default in the payment of rental as well as for the bona fide. Subsequently, bona fide news was withdrawn by the plaintiff. Original plaintiff died and the substituted legal heirs are now on record. After 6 years, they come to they file a petition saying that way back in 2016, the entire property has been sold up to someone else. And therefore, we are not interested in continuing with the suit. But the purchaser may kindly be substituted in our. The purchaser is not before the court. It is the original plaintiff. That is what we are objecting to. If you are not interested in pursuing your remedy, you can very well abandon or withdraw your suit. But how can you say that someone else has to come on record because the someone else is not interested and he has not approached? The impugned order, my lord, is at Annexure 14, page 115. It starts at 115. And the purchaser is not an unknown person. He is PW2 who deposed on behalf of the plaintiff in the suit. So he also knows about the pending suit, and even the sale deed also have a recital, my lord, that the suit is pending. But yet, the purchaser has not chosen so far, my lord, to come on record or to file any application. And otherwise also, my lord, the cause of action is very peculiar to the plaintiff. He is saying about default way back in the year 2009, May 2009. The purchaser has bought it in 2016. So if we consider section 54 of TPA, where the transfer of ownership has been defined, and read along with section 8 of TPA, ultimately the purchaser will be entitled to any rental or to speak about default about rental, my lord, after 2016. He cannot go back to 2009. 115 is the impugned order, my lord, and the 14.
Issue notice making it returnable on 17th of June 2024. Steps be taken against the respondent number 1 to 4 by way of registered as valid. Petition is further directed to take steps by way of the state to the registry of this court and file an affidavit of service on or before the next date. By way of the instant application under Article 7 of the Constitution, the petitioner herein have challenged the order dated 27/9/2023. 27/9. Why now? Why? What were you doing all this while?
There was the copy was received late, my lord. And secondly,
What
there
copy?
is
You were very much a party to this.
no copy to file the application. First and second, there is measurement going on in the state suit, which we don't want to oppose. Measurement of the good property. Because initially, the tenancy agreement said that the area of the rental is
No. You, why you have challenged now?
Hello.
On the next turnable date, the court after due service shall consider the question of stay, taking into account that the instant application has been filed. Challenge shall consider with the question of interim order taking into account that the instant application has been filed. On 26th of April 2024 against an order impugning an order dated 27/9/2023. Yes, have you filed?
Lordship, I have received the instruction process. It's basically a report on the analysis process that the ministry has done in regard to this case with the guideline process. We have received it. It has the affidavit has been the vetting of the affidavit is also been done. The process is going on, Lordship. I think in 1 or 2 days it will be filed, Lordship.
Okay, we'll have it on 27th.
I'm appearing for the attempt
20,
10, 11.
13th. We'll have it on 21st.
I'm appearing for the attempt. 10, 11. I have seen the order that has been passed by your law. That's, I think that's very important for the dot to come with a reply.
Because the dot, what they say out here will have a certain importance out here, taking into account they are responsible to have a look at or control the Airtel clock. Because on the face of it, Mr. Das, you have made the mistake.
Yes.
Airtel has made a mistake out there, the photographs and all these things. On the face
Because
of it.
your lordship was, because
Why we have brought in the dot out here for the purpose that once the dot comes up with that, then the burden which is otherwise to be imposed upon the state bank would be put.
I have seen, my lord, entire case I have seen. Because the lordship was in the view that POA and POI, that's very important. Because when we go and apply for a SIM, because I have seen the SIM has been lost on 1/10/2020. And this particular, whether you call it a processor, he goes to Airtel office and applies. And when you apply, you have to fill up the form. So your lordship was right to the extent that when it is filled up by this particular, you call it a processor also. And that particular, within 2 hours, this particular SIM is given. Maybe at 7:30 at 1/10/2020. SMS is different, 48 hours it gets activated. But whether it was a duty of the Airtel to look into the original document and verify.
Because that is,
That's why
that is already there in that the circular.
Yes, that's why I'm saying that whether in the back office, this particular was necessary for them to verify. Because apparently, your lordship is right. The date of birth in page 98 is shown as 11/4/1990, and it pays next with page 100, it is shown 1998. Maybe forget about the address of date of birth is date of birth. So let us wait and see the passed by the.
For the instruction of 2016, identity is required. Address is not a factor. There is another instruction of 2023. Here, Lordship, the location is there. And there are some discrepancies.
No. If you see, Mr. There is one thing which is there in that affidavit which is being filed. You see, kindly come to page 98.
98. The original application.
No. Yeah, the original. Now, original application says what is the photograph and all. This is the application and this is the photograph. And this is the original document, Rongia Higher Secondary School. Okay. See the area address, Rongia Murari.
That is there.
Murara.
I have seen.
Okay.
Yes.
This is what has been filled up. I'm not on that. The problem is, this is a different lady who has filed out there, and kindly see her town, village is Hiragata. Not only that, kindly see one very important thing. This particular lady, she also has a ID card. That okay, but kindly see this affidavit of respondent, affidavit filed by the petition. Yes, kindly come to page 137. What is the duty? The person at the POS, point of sale. Have you got it?
137.
Page 137.
2, Roman 2.
Roman. The person at the POS shall match the copy of the POI document submitted by the subscriber with its original, and also record a declaration on along with his or her name, signature, date, POS code, and so containing. So this is the document which is being submitted by the later person.
Lord.
That document he will verify. We are not on that. But number 3 is very relevant. Before activating of a new SIM card, the employee of the licensee who is activating the new SIM card shall verify that the details of the POI document
Lord.
submitted by the subscriber are matching with the records available with the licensee,
Lord.
and also record a declaration to the effect that a copy of the POI under his or her signature, designation, and year. This was not being done.
Yes, doctor. In regard to POI, there's mismatch. Doctor. Yes, this we have said in our this thing.
No. As regards the POI which was submitted,
Doctor.
if you see, that is why I am saying it. Kindly see, you can make out the difference. Kindly come to page 101.
Yes, 101.
101 is this lady who submitted.
Yes, doctor.
This is a fake identity.
Doctor.
Along with this document, 102.
Yes.
So this is, he made the verification in terms with Roman 2 properly. There's no quarrel. This document is to be seen with the original.
Right.
So similarly, this person who was at the point of sale have duly taken note of this aspect of the matter. But the question is, for issuance of the SIM you can, but to activate the SIM, you need to verify this document with the document which is there at page
It's 98.
99.
98.
This is the document which you not to have looked into. That is the case.
Also, this activation part is under the instruction of 2023 instruction notice. What it says that license.
No, there is already there in 2016. Why should we go to 2023 and make it more complicated for the petitioner? 2023 will look into it later on.
So the
This incident happened when?
21.
20.
Then
20.
don't bring out all this 2023 business. We are concerned with 1/8/2016, which categorically mandates number 3, which says that the licensee, before activating the SIM, has to check this document, the point of which was given, the identity document with the earlier identity document which is on record. And if that would have been seen, things would have been different. The case hinges only on this aspect, nothing beyond.
But there is one aspect of the matter, subject to correction by your lord. This person who has been arrested of doing all this process is not the first incident. There are other FIRs phone arrests has been shown. If you kindly look at page 37, I have checked the entire. Please look into 37. When he was arrested and forwarded before the magistrate, if you see paragraph 3, during the thorough interrogation of the accused so-and-so, revealed that on 24/9/2020, he along with another co-accused came to Rongia SBI ATM, where they collected the so-and-so victim accordingly, fake voter ID and replaced his mobile number so-and-so. One part is there, my lord, your lordship has said, to the extent of the liability of the Airtel, to the extent of POA and POI. Because
No, Mr. Das, kindly appreciate one thing. The thing is a bit different. First, when the matter came up before me, I asked the SBI, how is it possible that you can allow the change of the number when he has not even asked for internet banking?
Yes.
Then they came up with a circular by which it can be is possible with the if you have a SIM. This is how it has happened.
Because
Then-
on the, your lordship is right. Internet transaction was not there. Internet
He
transaction
never applied for
never
internet.
applied for
And
internet
these,
transaction.
all this amount has gone by internet.
But only I was just wondering, subject to your lordship, how the details of the bank card, everything was that particular, because if your lordship kindly see on 1/10/2020, there was absolutely no problem, 5,000. Thereafter, the withdrawal, again UPI. UPI doesn't need any OTP. UPI directly at the PIN number is general PIN number and auto. Third is SBI life insurance, which was due later on, it got credited from the account. So
No, UPI, I tell you.
yes,
UPI, what is to be done? It's like this. UPI is done, just for example, through Google.
correct. Google Pay.
You have your number.
Right.
Against your number, your SBI card is, your account is already there. You go to Google out there, Google account, Google Pay or Phone Pay or anything else. You just put your number out there and automatically it gives you against your number which are the accounts. The moment you do that, you select one, and with the selecting out there, you get your UPI address. Just for example, for me, if I have an SBI account, it will be Devashish Purva at the rate of SBI. Okay. Get it. You get that. Now, with this UPI address, you open a YONO account of the State Bank, and there you again use your mobile. And from there, you get everything. That is one. Or through Phone Pay or through Google Pay, you can make the UPI transaction on the basis of just inserting your number. You may go and during the lunchtime, you may try it out and find it out that this is how you can get your UPI done. If you don't have a Phone Pay or Page app out there, just try it out. The moment you put your number out there, they will immediately say that these are the 5 accounts against which it is there. You have all your accounts out there. So there is no the problem. The problem arises, therefore, I was thinking earlier they were saying that the UPI cannot be made. The UPI can also be made through this if you have the SIM.
But only I just worry about the correction, whether card details and everything is required. Then how the card details were, that's why I was thinking. The card details from where they got, the card details. If you see at page 82, the card details are required. I will address your lordship. Well, to the extent, the first affidavit in Airtel, maintainable, that's I will not go to it. It is maintainable and your lordship has got every under 226.
No, the
Only-
card details are required. For what? Why?
So, suppose you want to open a net banking.
You don't require the
No,
card
no.
details.
No, kindly see the procedure which has been laid down. I will address your lordship.
No.
That part.
If you require the card details also, that can be very well taken out. That is the biggest problem, the scam which is going on
My lord.
in the ATM and
I
all.
was going through it.
You just
They-
go to the ATM, you put money out there, the card out there. They use, therefore nowadays they have certain arrangements out there. But earlier it was there, you just put it out there, then you automatically get
That is
the
camera
scan.
automatic scan and
Yeah,
And
they get the
only,
details,
my lord,
everything.
Suppose I applied for a SIM and my SIM get lost. I go to the office and apply for a new SIM. Now the fraudster goes to the office. Let us take this term. The fraudster goes to the office, applies for the SIM. So once he gets the SIM back, so original that gets deactivated is not working out. So I was wondering that from second, third, everything is taken off. The second, third, fourth, the original goes to the particular to the Airtel office, applies it, and a new SIM is given. I was wondering the second, third, they were not aware of. What has happened? Because they normally we are so accustomed with our phone. Once for 5 minutes doesn't work, we get a lot of problem. That's the area I was thinking of. But for this negligence on the part POI, I have
Is-
seen that.
Person most likely even doesn't have a smartphone.
So that's
No, that's true.
Yeah.
You have to see that he is a retired person.
that's-
He got
that's
all
true.
his pension out there in that entire account.
that I
He may not have. He may not be like interested out there to get the number.
and what I felt, my
He
lord,
may say that okay, a person who is of the age of 65, 70 out there, he may still be getting used to the thing that yes, TNT at that point of time the phones you used to not there was the phones were not connected for years or months out there. So then also he must be used with that.
my lord.
For you, it is
smartphone-
something very strange.
My
Like
lord,
in the
smart-
affidavit filed by the SBI, they have specifically stated that these fraudsters, most of the time, like this retired person, old person,
Yes.
that is there in the
No,
affidavit.
they attack only the old person, what we have seen it. And normally, it is more safer to have the old phone than the smartphone.
Huh?
Old phones, which doesn't have that smartphone with all facilities, all type of things you can, but old phones without any facilities.
That is
then-
what he had.
No, that's
And with that, the other side has taken advantage. So all revolves around the SIM now. If you want to go for an application, just for example, this iMobile or, you need the credit card or debit card there. But for PhonePe, you don't. Or for Google Pay, you don't. The moment you put the number against that, automatically it comes
right.
with the deck.
Right.
And
Only
they
what-
automatically also give you the UPIs.
But only what is required is a PIN is required. Only the PIN.
No,
No, Google Pay PIN is required.
the PIN is you set it.
No, that's why one has to set it.
That is your PIN. This person, he had a normal phone. He never had a Google Pay. So you can automatically download that. You will put that number, and this is how it is being
Because
done.
there is no OTP in UPI. It's only the PIN has to be set.
No, then every against that OTP will come in. Chalo,
So we-
Mr. CK
Only
Purva.
one request, my lord, if it's not inconvenient, can it be on 22nd?
Okay,
22nd.
we'll have it on 22nd.
I am deeply up.
22nd. Mr. C.K. Purva, the learned counsel appearing on behalf of the Union of India submits that the affidavit is ready and would be filed in a day or two. Taking into account the above, list the matter again on 22nd of May 2024. The affidavit be filed not later than 16th of May with the advance copy to all the response petition and the
I am deeply up.
Yes, what is this?
So the matter is for disposal.
How many? 1, 9. Get us.
9 in 10.
Which are the cases? 347-39202.
347, yes.
तीनटा केस क्यों आई? In view of the law, matter be listed after completion of service. It will be listed as the revision stands disposed. Oh, 2 is disposed.
Who is disposed?
Okay. Yes, what is this case?
Your lordship will find the MP in order at page 17. The claim petition has been returned to the claimant under order. Lord, the learned judge missed section 166.
What is wrong?
So your lordship can restrict section 166, application for compensation. Now,
Yeah.
he was residing there. Now the jurisdiction comes from the claimant where he resides. So therefore, the provisions of law has been ignored by the Lord.
He has done you a favor, Mr. Datta. You are a claimant.
Yes.
You have not appeared all this while. So he says that let me return it so that he can file it before the appropriate court.
That's the appropriate court.
No, you have not appeared. You have shown that the claimant. It reveals from the case record the claimant is a resident of Karimganj and presently residing at Kachar. Why didn't you appear all this while?
That's my lord. I cannot
Then
say why he did not
go
appear.
to Karimganj.
But then your lordship has to see whether the jurisdiction is there or not.
Whether the jurisdiction is there or not, I think we should say that the claimant is not bothered with the matter for which the heir ought to have dismissed the claim petition as the claim is they don't want to prefer the claim. I think that should have been the order.
Lord, he stated that presently he is residing there at Paranka.
No, then why didn't you appear all this while?
Of course, the different aspects of the
The
matter.
court has been more kind enough, returning it to be deposited, placed before the appropriate court.
Now, when the question of jurisdiction was not raised by the other side,
Not really, he thought it good that I should do something for the claimant. Now it seems that he is actually a resident. Everybody is there. The accidents took place at Karimganj. Everything has happened out there. Let them go there. Rightly so. He should have dismissed it. You have not appeared for her. Afforded many dates
Yes,
to take it for taking steps in the case, but failed. You have not taken steps for all these while for 2 years.
these are your lordship is very correct. But then at the same time, the lordship can see whether there
I'll do one thing. I'll modify this order to the effect that the tribunal ought to have rejected this thing and we exercise 227 and reject the claim proceeding.
since the jurisdiction lies there.
No, lies it okay. Ought not to have returned it, but on these grounds should have dismissed it for non-prosecution because he doesn't want to take steps. So automatically.
So far ordered number 210 under the Motor Vehicle Act, this will not come up.
Not necessary.
What are the
I say that it is wrong. But I say that it is ought to have been dismissed because the claimant is not bothered. Now tell me, under what circumstances they will keep records? From 2014 onwards, you have not taken steps?
That's of course, my lord, that part of the part statement. Your lordship understands that how
I'm not going
things
to.
are going on.
And what is the other case?
Other case, my lord, that is also from Meghalaya. It was filed in there. Now, your lordship can see the impugn order. The same, my lord, the proposition has been taken.
Take steps. He has not been taking steps from 2012. You are appearing for this also. Are you appearing in this matter?
Yes,
also?
yes.
Huh? Give me an explanation as to why you have not appeared all this while.
Yes, my lord, very difficult.
Huh?
For me, it's very difficult. Why did you say?
We say that whatever may be, we are not inclined to interfere with this order.
The thing your lordship have to say that whether
No, sir, there has to, you see, we are exercising 227.
Right.
227, the conscience of the court has to be satisfied at least that you have been more diligent.
no, so for that part, I don't have to say
Yeah.
anything.
We are not satisfied at the conduct of the petitioner.
Conduct is up to
Yeah. Oh, because you see, one has to understand that all this while, you see, 2012, 12 years, the insurance people will have a lot of problem. Where will they get? And at the end of the day, you will say that you will be entitled to claim from interest from the date of filing of the claim petition.
That my lord, your lordship may observe for such period they are not entitled to get any. Your lordship can protect by The
I
officer
would
may
not protect, I will not. You have to, I'll take it at your submission that you categorically say that you would not claim any interest from the
Yes.
date of filing,
Def-
from the date of the incident till the restoration today.
Definitely.
And if you fail to take any further steps, then it can be dismissed. That is also an understanding you have submitted.
I endorse that.
I am only item number 9, Lordship.
Huh?
In item number 9, I am appearing. In 10, I am prepared.
Who is 10? Which insurance company?
National Insurance Company. National Insurance.
National Insurance Company. Whoever it is, let them go there and let notice be issued. And if they fail to take steps once, it can be dismissed for default.
Yes.
For non.
And one thing, Lordship, this case, I am appearing for respondent number 2. That was Bharti Axa Insurance Company, but now it is merged with ICICI Lombard. So we will be appearing for ICICI Lombard now.
TRP 347/2016. This is an application under Article 227 of the Constitution, challenging an order dated 23/6/2016, passed by the MAC, passed by the Learned Member Motor Accidents Claims Tribunal, Silchar, in MAC number 699/2013, whereby the application was returned by exercising the powers under Order 7, Rule 10 of the Code. Mr. S. Dutta, the learned senior counsel appearing on behalf of the appellant, petitioner, submitted that the learned tribunal would have dismissed the said claim petition on the ground that the claimant was not interested in pursuing the claim petition as the claimant had not taken any steps. But taking into account the provisions of Section 166 of the Motor Vehicles Act 1988, as it stood then, there is no amendment therein.
No.
As it of the Act of IMA. The learned tribunal could not have returned the claim petition by exercising the powers under Order 7, Rule 10 of the Code, as the court had the tribunal had the jurisdiction, as much as the claimant was a resident of Silchar. This court have duly perused the application. Perused the claim petition is here. This court have duly perused the claim petition, wherein it has been shown that the claimant was a resident of
At page 8.
Silchar. Under such circumstances, the tribunal, in view of Section 166 of the Motor Vehicles Act 1988, had the jurisdiction to decide the said claim petition. But the learned tribunal, having returned the claim petition on the ground that the tribunal did not have the jurisdiction, amounts to a jurisdictional error for which This court interferes with the order dated 23/6/2016. Mr. H.S. Aikya, the learned counsel who appears on behalf of the respondent number 2, submits that Bharati AXA General Insurance Company Limited no longer exists, as the same merged with the ICICI Lombard
General Insurance Company.
General Insurance Limited. And the later company have also taken over all the assets and liabilities of Bharati AXA General Insurance Company Limited. Taking into account the above, Mr. S. Datta, the learned senior counsel, submitted that due changes would be made in the claim petition, incorporating the insurance company who would now be liable as per the claim made. This court, taking into account both the parties are appearing before this court. The parties are represented before this court. This court directs the parties to appear before the learned member Motor Accidents Claims Tribunal, Silchar, on 10th of June 2024. Records actually 9/24. First, before parting with the record, this court makes it very clear that the claimant out here, that the petitioner herein, have been totally negligent in pursuing the proceedings before the learned tribunal. It is seen from the impugned order itself that for almost 2 years, the claimant did not take steps. It is also seen that the order dated 2000, the impugned order is of the year 2016, and the same is now being interfered with by this court in the year 2024. Taking into account this above, this court observed that the claimant shall not be entitled to the interest in terms with Section 171 of the Motor Vehicles Act 1988 from the date of filing of the claim application till today. The tribunal shall be at liberty to consider entitlement of interest, if any, post the order passed today. It is also made clear that if the claimant fails to take steps, this court, the tribunal, shall be at liberty to pass such orders as is conceived in the law. Itu tu kali ikon before itu tiap order to belek apa you see why you are asking that it should be at Silchar in this case?
It's citing here present.
Kindly see your petitioner's address in the second one.
That's the village Barangay.
See the second 392. The petitioner.
My lord, this 392 you lord mistake. Now the petitioner is my lord Jayantia Health Meghalaya.
Then?
Now the defendant is from that area.
Who?
Is the national insurance.
It's a branch only.
Yes, if the office is there, but the my lord, if you look at section 166(2),
That I understand.
my lord.
There's no quarrel. That why this order should be, it has been returned so that it moves.
Not exactly because if the
Because you are not taking steps.
that's exactly, my lord. I don't have any quarrel on that.
You also say that you are a resident of Jayantia Hills.
Right.
Why do you want it in Silchar?
But they filed it for what is the difficult thing.
No, you have to say. You can't say that you evade. There I understand. It's Silchar. But here, how do you say that? See the order. Learned counsel for the claimant prayed adjournment by petition due to absence of the claimant. Peruse contents. Payment 1 day, 2 day, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15,
Number of
16,
days.
17, 18, 19. 19 dates. But failed. The court says that okay, go there. Have it again file it. Because there is no bar when it is in return. Then, and there is no limitation problem. As of this, there is no limitation.
The petition is now there at that relevant time.
There is no limitation. Why are you not filing it in Jayantia Hill? He is there. Why does he have to come all the way to Silchar? Or does he have some fancy? Or has a second home there?
Lordship knows that the lawyer of the claimant cannot possibly their choice.
No. It's not. That is the problem.
Yes, I understand all that.
That he's not. I think the claimant is not interested.
Maybe.
Claimant is not interested with this claim.
Yes.
The lawyer is more interested.
Yes.
And because of the lawyer, now you become interested. Otherwise, what?
I'm not interested.
Absolutely, there is some interest.
I'm
No, the lawyer's only thing is the claimant is not taking steps. Maybe the lawyer must have not got certain things.
Maybe. So these are the reasons. My lord,
Here it is okay. The
happens.
owner and driver are also resident of Meghalaya. You may have her in Silchar. Why it is required in Silchar when the accident took place at where? Where did the accident take place?
Accident possibly there at Meghalaya.
Huh? Owner is from Guwahati. Driver is from here, Guwahati. Driver of the minibus is from Guwahati.
Lord, your lordship
Accident
very well
took place
understand.
at Joy. See, accident took place at Joy.
Yes.
Then,
Your lordship very well understand why this thing.
then can you make tomorrow? Why don't you file it in Rajasthan? You file it in Rajasthan. Very well. They also have an office. Go to Delhi. Absolutely right order. No, let me come back in 5 minutes.
Sure.
It needs to be dismissed. Under Article 7 of the Constitution, challenging the order dated 27/2016, passed by the learned member, Motor Accidents Claims Tribunal, Silchar, in MAC case number 319/2010, whereby the claim proceeding was returned on the ground that the learned tribunal did not have jurisdiction. This court had duly taken note of that a claimant is a resident of Joy, in the Jaintia Hills, Meghalaya. The accident took place within the jurisdiction of Joai PS and have been registered as Joai PS case number 06 bracket 101 0 bracket closed 09 under section 279 oblique 304 bracket A oblique 338 of the Indian Penal Code. The owner of the vehicle of one vehicle is a resident of Jaintia Hills or of the district of Jaintia Hills. The owner and driver of the vehicle of one vehicle are residents of Jaintia Hills, district of Jaintia Hills, Meghalaya. Whereas the owner and driver of the other vehicle are residents of Guwahati. It is further seen that the claimant had not taken steps in the matter on on 20 occasions, that is since 14/8/2012 to 27/2016. Under such circumstances, the learned tribunal held that the tribunal had no jurisdiction and accordingly returned the claim petition to the claimant in terms with Order 7, Rule 10 of the Code of Civil Procedure. This court, taking into account the claim petition as well as the order so impugned in the instant proceedings, is of the opinion that the order impugned does not call for any interference from this court. As the claimant is a resident of Jaintia Hills, the accident took place in the district of Jaintia Hills. The owner and driver of one vehicle are resident of the district of Jaintia Hills, and the owner and driver of the other vehicle are residents of Guwahati. Accordingly, the instant petition stands dismissed.
I think it is better you will observe that for such period if they are not entitled to get any.
Not necessarily, it is returned.
It is gone there.
It is not gone there. They have not exercised the powers under Order 7, Rule 10A. It is done by which it is being returned. So once it is returned, you have to freshly file. Once you freshly file, then 171 kicks in.
Otherwise, they will be enjoying it for
Huh?
therefore. Like
What is this? You're challenging which order?
Changing order dated 4/9/2017, page 98.
Yes.
Today is posted for order on petition number 20. Petition 20 has been filed by the,
Who are you?
I am one of the plaintiffs.
Then
I filed the suit along with my husband. I am second wife of the plaintiff number one. I filed the suit along with him for declaration of right, title, and interest, and for confirmation of what the respondent, hearing where the defendants in the they are my first wife and children from the plaintiff number. And my suit was based on adverse position. Originally, the suit line was of one Kamlakanta Kolita. He died and he has no issues. His wife inherited the property. Bakiwala Das. My lord, Bakiwala Dasya also died in the year 1999. I filed the suit that I am possessing the land since 1971. In 1985, I got the mutation of the land, mutation of the houses standing on the land, and Bakiwala Dasya raised objection with the Guwahati Municipal Corporation regarding my topic. Guwahati Municipal Corporation rejected that her objection. Then my lord and suggested that if he has any grievances, he can go to the civil court for declaration. He did not approach the civil court, and ultimately she died. Their respondent defendant, they claimed that they are the legal heirs of Bakiwala Dasya. And ultimately the suit was dismissed. The trial court thought that as there is no legal heirs of Bakiwala Dasya or Kamlakanta Kolita, the property will be issued. Then, Your Honor, I filed the appeal. Appellate court remanded back the suit to the trial court, remaining two issues. On those two issues, the suit is to be proceeded. My lord, the third para, my lord. What was the source from where Bakiwala Dasya got the suit land? Number two, whether there are any legal heirs of her husband or the legal heirs of late Bakiwala Dasya at the time of her death. If so, who are they?
So
Then,
what
my
did
lord,
you ask for?
Madam,
What are you asking for in your petition?
my lord,
What petition has been rejected?
no. Then, my lord, the suit was again started with the trial court. I filed a petition, order 1 rule 10(2) of CPC for implement of the legal heirs of husband of Bakiwala. Because as per section 15 and 16 of the Succession Act, if any male or female, if any female expired, issue left, intestate, then if she got the property from her husband's side, then it will be inherited by the legal heirs of her husband from his father or mother. If she got the property from her own mother and father, then the property will go to them. So I filed the petition under order 1 rule 10(2) that the Bakiwala Dasya husband had legal heirs, and I listed their names so they may be implemented. Because the additional issues were framed that whether the Bakiwala Dasya or her husband has any legal heirs. The learned trial court my lord, page 102. 10.
Yes.
Last paragraph, my lord. Third page is DR. Here in this present plaintiff number 2 held that the extent petition for addition of the legal rights of Bhogiwala Dasya who died intestate and without any having issue. Bhogiwala Dasya expired on 27/3/99 and her husband late Kamlakant Bora was the only son from his first wife of father Manik Kalita. And after the death of his mother, the first wife of his father, the present plaintiff number 2 has prayed for improvement of the legal rights from his stepmother, that is second wife of his father, at the time of death of Kamlakanta Bora. The name of the legal rights of late Kamlakanta Bora born out of the wedlock of second wife of his father. In order to implement of legal rights of late Bhogiwala Dasya, we have to go to the Hindu Succession Act 1956, wherein section 15 of the said act provides a scheme of the succession to the property of a female Hindu who dies intestate after the commencement of this act. However, if we see section 8 of the Schedule 1, section 8 of the Schedule 1 and Schedule 2 of the Succession Act, then we find that there is no specific clause for inheritance of the property of female Hindu who is intestate as well as issueless by the legal rights of stepmother of her husband. As such, hence the Schedule 1 and 2 is completely silent about this matter. Hence, the implement of the legal rights of the stepmother of the husband of that Bhogiwala Dasya is not tenable under the.
Earlier, Bhogiwala Dasya and Kamalakanta Bora, they were parties to the suit.
After the death of Bhogiwala Dasya, the suit was filed. Because the respondent claimed that they are the legal rights of Bhogiwala. They got mutation of the land before filing of. That's why I challenge their title. Also, the mutation they got from the revenue.
Wahagi Kolipya.
आगे पलिता आगे वाला व्यक्तियों आगे वाला पका कहते हैं.
Show me your petition.
My lord, page 70. The plaintiff number 2 jointly with plaintiff number 1 filed the above suit for declaration and show. Next method. That the plaintiff number 2 states that impugning the judgment and decree of this honorable court, whereby the suit filed the plaintiff was dismissed on contest with court, the plaintiff suffered an appeal being so in the court of.
And when you filed a suit in 2006,
additionally, she was framed. Then, para 3, the plaintiff number 2 on inquiry came to know that one Kamlakanta Bora, alias Kamlakanta Kolita, son of late Mani Kolita, was the absolute owner of the suit land and was married to Bhogiwala Dasya. They had no issue. The said Kamlakanta Bora died intestate, and as such, after the death of her husband, Bhogiwala Dasya inherited the suit land from her husband. Thereafter, Bhogiwala
now what
Dasya,
is your case?
my case is that when the
Yes, your claim. You are asking for adverse position against whom?
against the respondent, and now if the legal rights are implemented in the suit, then against the legal.
So you have as of now there is no pleadings. You have not made the pleading.
No, I have filed the suit. Earlier, I
You-
had no knowledge about the legal rights of the Bhogiwala.
So the moment you do that,
Then I filed the petition.
so how can you have an adverse possession against somebody whom you don't know?
No, when the respondent, they are claiming the title on behalf of the Bhujiwala Dasya. That's why I filed the suit against them.
Understood. So you are asking for why you are making those people a party?
Because the net appellate court wants to know whether there is any legal act from her husband, Manik Gupta, or the Bhujiwala.
No, you were having adverse possession against those persons. Against Bogibala, what is his name? Bogibala Dosha. You had adverse possession against Komalakanta Bora and Bogibala Dosha.
Then Bhujiwala Dasya told me to take Kamlakant, but he is no more. He was no more at the time of filing for the suit.
Understood. So you claim that you have been in possession since when?
Since 1985. At
So-
best,
Huh?
because 1971, I am in the position 1971. But in 1985, I got notice of the holding. Then the Bhujiwala Dasya raised objection. And her objection was rejected by the EMC authority.
Now, why you are asking adverse possession against them,
Because
against
they,
the defendants?
because they got mutation of the land, claiming them as the legal rights for Bhujiwala Dasya.
So now you are asking for adverse possession against them also. Then why you are making somebody else again a part?
Because the Learned Appellate Court,
The appellate court may have done that, but the problem which will arise out here is for you is many more. What is the
what was
source
the source?
from where Bogibala got the land? That is the first.
Yes. Second,
Whether there are any legal heirs of her husband or legal heirs of late Bogibala Dosha at the time of her death.
Yes.
If so, who are they?
Yes.
For that, you need to amend your pleadings. Why you need to make them parties?
because they will come and they will say for the court. That's why implementing them as a party. And they will say, they will come to the court, they will say that we are the legal heirs of Bhujiwala Dasya through her husband.
Bring them as a witness for that if you have. Why you making them a party?
Now, how they will come? How they will come?
Order 16 rules 1. What you are asking, your suit is for adverse possession against the defendants, saying that you have possession from the time of from 1963 onwards, 71, and then in 1985 you got your mutation of whatever may be. So you have a right over that and adverse possession, whoever it is. Now, if you want to bring somebody else out here that they who is not claiming anything, nothing does, even I think they don't know that their right is devolved upon them.
No, but I have done on the basis of the additional issue number 2. That who are the legal heirs of Bhujiwala Dasya or her husband?
So if you don't bring in, has the other side brought anybody?
No.
So the moment you bring somebody else, is your adverse possession, do you still continue to have an adverse possession?
Let them say.
No. Can you claim to be in adverse possession against somebody whom you don't know? Because your entire suit goes.
Then my right will be adversely affected. Then the suit is decided for the non-joinder of necessary party. Because earlier the trial court,
Have they accepted out there that these are the legal heirs? The respondent, have they said in their objection, yes, they are the legal heirs?
Yes.
Let's see their objection.
Page 87.
Where?
87.
are fabricated and false. It is stated that the father of so-and-so is not the son of Manik Kolita. Documents enclosed herewith will show that the father of Kamala Kolita is Harisharan Baran, and that being so, the statement made in the petition to sought to implead the alleged legal heirs of Kamala Kolita is blatant lie, and on this score the plaintiffs are here. So, where do they say that these are the people?
They say that they tell the name of the father of the Kamala College. I filed the next petition. Page 91, my.
Yes.
There are three, my lord.
Yes.
The plaintiff number 2 begs to state as per information gathered by her, the name of the father of Kamlakant Gora, alias Kamlakant Kolita, was Manik Kolita, and in support of her claim, she collected photocopy of voter list for the year 1966 of the constitutional so, where serial number 11, the voter's name Kalyaram Kolita has been mentioned with his father as Manik, and also serial number 27, name of the plaintiff number 1, Devaru Burman, is stated, and serial number 29, Bobibala Bora has bench Nam Kamlakan is stated. Again, plaintiff number 2 has also collected NRC details of Kalyaram Kolita. Kalyaram Kolita is the brother of husband of the Bobibala, whose father's name is mentioned as Manik, and in other NRC details, Chandrakant Kolita.
But without seeking an impleadment, with an amendment to the plaint, can you do that? Are you not asking for adverse possession against them?
Not it.
What? Then why do you require them?
No, no. Just that one to treat them. And let them come and say that they are not a legal heirs.
For that, is it necessary to make them a party?
Yes,
Is it?
why not?
Why?
Because they will come. Because otherwise,
You have by force brought them out there. You say, bring them as witness.
my lord, earlier the trial court has dismissed my suit, that the suit is paid for non-gender of my party.
The trial court dismissed it.
Earlier, the appellate court modified, and the appellate court remanded the suit, framing these two petitions.
But isn't it the requirement of the CPC that you have to give a statement who are the defendants in your plaint? Order 7, Rule 1, a description of the defendants. How do you do that if you don't implead them, make amendment to the plaint? See Order 7, Rule 1.
Particulars to be contained in the plaint shall contain the following particulars: name of the court, description of the plaintiff, residence of the plaintiff, description of the defendant, and the if the defendant is minor or person of facts constituting the cause.
Do you have a cause of action against those? If you have a cause of action, isn't it required to implead? Because more particularly when it is a case of adverse possession, it will have serious implications. When they are not saying, have they stated? Let's see, it's a different thing. Let's see the written statement, amended written statement file. Where do they say they take the play of unnecessary parties? Land originally, kindly come to page 34. Land, suit land originally belonged to so-and-so, allied so-and-so, so-and-so, wife of heir, and then she was issueless. The rest of the government made so-and-so. Welfare brought about this so-and-so, so-and-so. Where do they say? Some misunderstand at the instigation of other raised objection before the court is raised so-and-so, so-and-so.
My lord,
If they are claiming title,
page 32,
Hmm.
there are three. The suit is paid for non-joinder and misjoinder of
understood, but isn't that the Supreme Court judgment that when you are taking the point of misjoinder and non-joinder, you are to specify which are the persons who are there? Isn't that the law? It is clear from the Supreme Court judgment that you can't just take a empty plea bad for non-joinder or misjoinder of parties. You are to categorically say that why this person is not there. You can't take people for surprise. That's the law. Because you see, what you are asking for, it's okay. Making them a party. You want to make them a party, you are the dominant splitters. You can very well make the party. But where, why? Isn't it required for you to amend the plaint? You see, the Supreme Court in this judgment more particularly says 92 2 SCC 524 object of making them a party Sub-rule 2 of Rule 10 gives a wide discretion to the court to meet every case of defect of parties and is not affected by the inaction of the plaintiff to bring the necessary parties on record. The question of impleadment of a party has to be decided on the touchstone of Order 1 Rule 10, which provides that only a necessary or a proper party may be added. A necessary party is one without whom no order can be made effectively. Now tell me, on the basis of your contents of your plaint, without seeking an amendment, are they necessary parties? No. A proper party is one in whose absence or effective order can be made, but whose presence is necessary for complete and final decision on the question involved. The addition of parties is generally not a question of initial discretion of the jurisdiction, but is of judicial discretion. Then there is another one thing. It cannot be said that the main object of the rule is to prevent multiplicity of actions, though it may incidentally have there. But that appears to be a desirable consequence. The person to be joined must be one whose presence is necessary as a party. What makes a person a necessary party is not merely that he has relevant evidence to give on some of the questions involved. That would only make him a necessary witness. It is not merely that he has an interest in the correct solution of some question involved and has thought of relevant arguments to advance. The only reason which makes it necessary to make a person a party to an action is that he should be bound by the result of the action and the question to be settled. Therefore, must be a question in the action which cannot be effectually and completely settled unless he is a party. The line has drawn on a wider construction of the rule between direct interest or a legal interest and commercial interest. It is therefore necessary that a person must be directly or legally interested in the action. In the answer, that is, he can say that the litigation may lead to a result which will affect him legally, that is, curtailing his legal rights. It is difficult to say that the rule contemplates joining as a defendant a person whose only object is to prosecute his own cause of action. Then you say 1993 3 SCC page 49 categorically says that it has to be, you have to say it, who are the necessary parties. There is no pleadings to that effect.
I will amend the plan. Will amend the plan.
You have to bring those without making that, how is it relevant? What to do? You are there? Yes.
Under trial court lordship, rightly held that this person not a legal heirs lordship. These persons who he tried to implement lordship.
So the moment he says they are not legal heirs, why do you need them?
Even the plaintiff number 1 lordship objected the petition of plaintiff number 2. Plaintiff number 1 objected the petition filed by the plaintiff number 2.
No, because Mr. Jain, what you are, is a big problem you are going to face if you make them without pleadings.
I will.
Because how do you say that you are still adversely possessing against the interest of those? You just want to bring them. But why you are bringing them is not there. And in fact, the second additional issue which is being raised by the appellate authority, they are not saying that these are persons are there. So is it your case that whoever may be, whoever has claimed any right on the basis of this Basabi Dasha would be bound by your adverse possession? Because your right of adverse possession, you are still in occupation. So from beginning you are there against the earlier person, then Basabi Dasha, and after Basabi Dasha, whoever claims it. Maybe if it has gone to the state also, state you can't because of the 30 years. But otherwise, if it is otherwise any other person out there, you need.
I will amend the.
What to do with this order? This order has a ramification. Once you impede this order, this order needs to be interfered with to a certain extent, because you can't amend also without impeding. Isn't it? What do you say about Order 1 Rule 10.4?
Only second claims to be joined for recovery of removal.
Where a defendant is added, the plain shall, unless the court otherwise directs, be amended in such manner as may be necessary, and amended copies of the summons or reas shall be served. How do I interfere with this?
The next trial court is only read the section 15 of the Section, not 16. 15 or 16 are interrelated.
Now that I know. It goes back to that, if the property is acquired from the father's side, the husband's side, it goes to the husband's relatives. If it is from the mother's side, it goes to the mother. That is okay. But how do I interfere with this? Because if I don't interfere, you can't file an amendment. And without an amendment, this application is, yeah. This is an application filed under Article 227 of the Constitution, challenging the order dated 4/9/2017, passed in title suit number 353/2006, whereby the petition number 2060/2017 What is 2305?
Second petition, where I
Oh.
give details of the other of the
Whereby the petition number 2060 and 2305 were rejected by the learned trial court. That is the court of which court?
Municip number 2, Kamrup Metro Court.
Munsif number 2, Kamrup Metro at Guwahati. For discerning as to whether the order impugned requires an interference by this court under Article 227 of the Constitution, this court finds it relevant to take note of the brief facts leading to the leading to the passing of the impugned orders. The petitioner herein, how many petitioners?
One.
The petitioner herein is the plaintiff number 2. Your husband is alive?
No.
He did.
He expired.
Okay. The petitioner herein is the plaintiff number 2 in title suit number 223/2000. The petitioner, along with her husband, who was the plaintiff number 1, who expired during the pendency of the suit, filed a suit seeking seeking declaration of their right, title, and interest in respect to the suit land described in the schedule to the plain on the basis of adverse possession. And also sought for various consequential orders, consequential reliefs on the basis of such declaration. The defendants filed a written statement denying the claim of the plaintiff. On 19th of May 2011, the said title suit filed by the plaintiff was dismissed. With cost. Being aggrieved, the plaintiffs preferred an appeal, being title appeal number 48/2011 before the court of the civil judge number 1, Kamrup Metro at Guwahati. The said appeal was disposed of by an order dated 12/8/2015, thereby remanding the suit back to the learned trial court to decide afresh
on 2 additional. Page 72.
No, they exercise the power under order 41 rule 25. 25 is when the appeal is remaining. It should have been an order, maybe they have framed additional issues, but it will be under 23A. Remanded the suit back to the learned trial court by framing 2 additional issues. 。 The said additional issues were, number one, what was the source from where late Bogibala Dosya got the suit land? Question mark. Number two, whether there are any legal heirs of her husband or the legal heirs of late Bogibala Dosya at the time of her death, inverted comma, and a question mark. If so, who are they? Question. Upon the suit being remanded back to the court of the Munsif number 2, Learned Munsif number 2, Kamrup Metro at Guwahati, the petitioner number 2, this is filed by petitioner number 2.
Plaintiff number 2 petition.
Huh?
Plaintiff number 2.
The petitioner herein, as plaintiff number 2, filed an application under Order 1, Rule 10(2) of the Code of Civil Procedure 1908, for short the Code, for addition of the legal heirs of late,
Kamalakanta Boda.
who, legal heirs of whose? Of Bogibala Dosya.
He got the property from her husband's legal heir.
You are saying about her husband of legal heirs of late Kamalakanta Kolita.
Kamalakanta Bora.
Bora Kamalakanta Kolita. Kamalakanta Bora. To whom, by virtue of Section 16 of the Hindu Succession Act 1956, the property reverted, the suit property reverted upon the death of late Bogibala Dosya. Surprisingly, the plaintiff number 1 filed an objection to the petition filed by the plaintiff number 2. Stating inter alia that the said persons whose names have been mentioned in the application were not the legal heir of late Bogibala Dosya as well as of her husband. The other defendants also, filed objections stating inter alia that the said application on the face of it was not tenable and was a case of a blatant lie. It is under such circumstances the petitioner filed another application
2305.
bearing number 2305/2017, thereby stating that that late Kamalakanta Bora Kolita had two brothers, namely Kolia Ram Kolita and Chandra Kanta Kolita. And the property, therefore, and as those persons, those brothers of late Komala Kanta Bora had legal representative, the property, therefore, devolved upon him in terms with Section 16 of the Hindu Succession Act. The learned trial court, by the order dated 49/2017, rejected both the petitions by taking into account Section 15 of the Hindu Succession Act. The Hindu Hindu in India. পাত্তাই অপু। Read with Section 8 and Schedule Roman 1 and Roman 2 of the Hindu Succession Act. It is under such circumstances that the instant application has been filed, challenging the order dated.
Section 8 is only for male member.
4/9/2017. What?
Section 8. This section. It won't come here.
So this Section 8 would duly apply in respect to
If the male died
interstate. No, that is Kamalakanta Kolita, it will apply.
yeah, if he died intestate.
He also died interstate.
No, but we are dealing with their Bogibala, his wife.
No, therefore, you will go to Bogibala and then revert. This reversion is here, notwithstanding any property inherited by a female Hindu from her father or mother. In 2B, 15 2B. I can go. Did you? 15 2B, notwithstanding anything contained in 1, any property inherited by a female Hindu from her husband or from her father-in-law shall devolve in the absence of any son or daughter, including heir, not upon the other heirs referred to in subsection 1 in the order specified therein, but upon the heirs of the husband. So it reverts. And then you again apply 8.
16. No,
No.
it will not come. 16. section 16.
Why? The order of among the heirs referred to in section 15 shall be, and the amongst the heirs of so and so and 15, if any son or heir have predeceased the so and so heir, the devolution and one and
These
two,
two sections are interconnected.
the devolution of the property of the interstate on the heir referred to in or B, D, and E of subsection 1 or in shall be in the same order and according to the same rules as the prescribed. That is why, if you see 16.3, the moment 16.3 comes, then you go back to rule 8, section 8. There again, therefore, he becomes a class 2 heir. You see here, the schedule. Here, class 2 heir, son, daughter, brother, brother's son. You see, class 2. Therefore, once 15.2b comes in, and then it goes and becomes 8 because of 16. So, what has duly taken note of, but the main problem is you will be in more trouble. This court had heard Mr. R.K. Jain, the learned counsel, appearing on behalf of the petitioner, and Mr.
Sharma Lordship.
So and so appearing on behalf of the respondent number
4 and 7. 1, 2, 3, 4, and 7.
3, 4. This court have duly taken note of the impugned order. Wherein the learned trial court had rejected the application by taking into account section 15 of the Hindu Succession Act 1956 and reading the same along with section 8 of the said act. But in doing so, the learned trial court failed to observe the provisions of section 15(2)(b) in of the Hindu Succession Act 1956, the Act of 56, in the proper perspective. In as much as if the provision of section 15(2)(b) is attracted, the same has to be then read with Rule 3 of section 16, which consequently will come back to section 8 and schedule 2, schedule 2 of the Act of 1956. The question as to whether late Kamalakanta Kolita had two brothers or not have not been touched by the learned trial court. The further question as to whether the property devolved, the suit property originally belonged to late Kamalakanta Kolita and upon his death to his wife, late Bogibala Dosya, is not in dispute. It's not in dispute. The question therefore arises, which the learned trial court ought to have decided, is as to whether Komalakanta Kolita had two brothers as alleged, and as to whether the plaintiff, being the dominus litis, would have a right to implead them in the suit. The learned trial court, having not done so, in the opinion of this court, the impugn order requires.
He had three brothers.
You said two brothers.
Three brothers. Page 19.
No. Kindly see your petition. He judge may write many things. Kindly come to page 92.
Page 78 my petition.
Huh?
Page 78 of my petition.
Page 92. Last line of para 3.
Yeah.
Anyways, how many brothers is there? Therefore, requires to be interfered. This court further, during the course of the hearing, Mr. Arkatin, the learned counsel, appearing on behalf of the petitioner, however, submitted that taking into account the scope of the suit, the application under Order 1, Rule 10 ought not to have been filed without also simultaneously seeking amendment of the plaintiff. He submits that the plaintiff may be given the permission to do so. The petitioner may be permission to do so. This court is of the opinion that the permission or the leave to grant permission for filing an amendment to the claim lies with the trial court before whom the suit is pending. And for seeking such amendment, the plaintiff would be required to file appropriate application. And the learned trial court has also to consider as to whether the said amendment would be permitted. Accordingly, this court therefore disposes of the instant petition by interfering with the order dated 4/9/2022, 2017, and directing the learned trial court to decide the said application on the basis of the above observations. The above observations pertaining to amendment of the plain shall not preclude the plaintiff to file appropriate application before the learned trial court. And in such circumstances, if such application is filed, the learned trial court shall duly consider the same in accordance with law. Taking into account that both the parties, there is a stay?
No.
What happened to the suit? What happened to the suit?
Stay.
Then that is what I am asking. Taking into account that by the order dated 21/7/2017, the further proceedings of title suit number 356 of 2006 was stayed. This court vacates the said stay order and directs the parties to appear before the learned trial court on 10/6/2024.
Again, the problem will come in whether the amendment petition I can file the implement.
Huh?
Whether in the amendment petition I can file implement of the legal act.
You have, let this petition remain in a year, you can do it. I for what?
What is stating that the two brothers lordship, to the step brother, not the foot present brother.
There may be, that is what the trial court should have decided. अब आता line लिखी हाँ court he can लिखी थी that the police shall decide the application for setting aside the order dated 14/9/2017 and direct the learned trial court to decide the same application without being influenced by the observations made as to whether late Komala Kanta Kolita or late had any legal heir. But Mr. Jain, you will be in trouble with that thing because you don't know who is the owner.
They are claiming they are the owner.
So very well, you should fight against them.
I filed the suit against them.
Yeah? You are coming up with all these things. Yes.
My lord, I'm appearing for the respondent of one on behalf of 50%. Last
Yes.
case, my lord,
What is the case you have filed?
my lord, the case is that the file our statement within 88 days.
Huh?
On the 88 days from the date of receipt of the plate and copy.
Written statement. Today is the 98th day for filing WS by the defendant number 11 as mandatory. Hence, no further time can be granted here. Which order? 5/3/2018.
5/3/2018 may kindly be perused there. The learned trial court has specifically mentioned that I have received copies of the document on 8/2/2018 month. Page number 64, 65 kindly there. There
Which order?
for order dated 5/3/2008.
5?
5/3/2008.
Then you are for the plaintiff.
I'm for the defendant.
Then,
I'm for the defendant. The defendant number
no, which is the last order you are challenging?
last order here, my lord, is order dated 21/2018 as well as this 9/4/2018 at 23/9/2000.
Mr. Nandi, are you aware which is the impugned order?
Impugned order is, my lord. I have made all these three as an impugned order.
Which three?
This order.
5/3/2018 was already reviewed by the learned trial court.
My lord.
21/2018.
Thereafter
You say that summons on air was served on so and so. Then today, 5/3/2008 is the 98th day, and as such, defend number 11. Who are you?
I am not 11, my lord.
What is your?
I am the defendant number 3, 5, 6, 7, and 9.
353 and yeah, seen petition number for filing, copy of the plaintiff received, heard, considered, and also seen petition number 10 any month. Fixed 9 4 for WS of 3, 5, and 9. SR and WS.
Right.
That is 5/3. And what is that?
5,
I don't see it. Why the petition? Why this order says 3, 5, and 9, whereas seen petition filed by the defendant number 3, 5, 6, 7, 8, and 9. You are appearing for whom?
I am appearing for this defendant number 3, 5, 6, 7, 8, and
So you have filed a petition on 5/3/2018.
5/3/2018. We have informed the learned trial court that we have received the copies on 8/2/2018. So we will be filing our written statement. And because
Okay, so then 5 days. So you will be time granted.
time granted,
Then
and
for
thereafter,
WS,
my lord, on 9/4/2018, that by this order,
why is 9/4/2018?
is page number 67, by which my prayer for time to file my written statement has been rejected.
Where is 9/4/2018? It is fixed on 9/4 for 3, 5 to 9.
My,
Yes, then
I'm the defendant. There I have informed that I have received the copy, but some other documents are required, so I may be given some time to complete my written statement.
when did you inform?
My this thing on 9/4 I have informed, and on 5/8/2018 I have filed my written statement. But on 9/4 itself, on the plea, if my lord, page number 67, the defendants have also taken the plea that they have received the document on 8/2018.
No, this is before.
Yes.
3, 5, 6, 7, and 9 are precluded from filing written statement. However, they can take part in cross-examination. Then
So, my lord, I have filed it.
you
By-
file an order 47.
Yeah, my order 47 along
And-
with my petition.
You
Then-
file your written statement.
Yes,
Did you submit your written statement
I
on
have already
5/6/2018?
5/2018. That is within on the 88th day.
Defendant had earlier filed written statement on 5/3/2018. Which one? Huh? Where?
5/8/2018.
When did you file your written statement?
I have filed it on 5/8/2018. My
Where? Where is
petition
it mentioned?
may kindly be perused.
How is it possible 5/8/2018? There is no date.
No, it was on an off date.
Where?
This 5/8/2000.
After being barred.
Yes. Learned Court has barred me by order dated 4/8/2008. That is
5/4/2018.
there is
When is the next date? Where is
after,
your orders being not properly enclosed here?
my lord, I have annexed all the orders.
You have not enclosed the orders in a proper manner.
My lord, after this 4/8, if lordship kindly peruse 9/4/2018, thereafter the next date has been fixed on 5/6/2018.
Nah, that I've seen.
And before that, on 5/8/2018.
How can we 5/6/2018? How can there be 5/8 before that?
My lord, I have filed it because so that
Agree.
it is filed within
Is
90
it possible? Can 5/8 happen before 5/6?
days. No, my lord. It is
Then
8/8/5. Sorry.
Then why you're not saying that?
Sorry.
8/5.
It is 8/5. 8/5.
Where is it mentioned anywhere on record?
My lord, my petition may kindly be perused that on page number 56
No, it is not mentioned anywhere in the record.
in the record.
In any of the order sheets that you file the written statement.
My lord, that has come on the order dated 9. In this order dated, my lord, it is on 23/9/2019, by which my petition, both the review as well as the petition to
Where is
accept the written- it is the
Which-
page number 75.
That is okay. Where you have filed your written statement has been filed.
My lord,
Mentioned.
is
Where?
my lord here.
We say that a lawyer doesn't know anything. We dismiss it on that ground. You don't know, have a head and tail. Where is it?
My lord,
It's not mentioned out there in that order.
my lord, my petition number is mentioned. In the,
Petition, but where is it on record that you have filed your written statement on 585? You also don't know. 8558, you don't know
my-
when.
this
There's no mention anywhere.
very petition,
Where is your statement in your plain,
my lord,
in your written statement, in your petition that you on 5885 you have filed?
my lord, my petition may kindly be perused that I
Yes,
have,
Mr. Counsel. Paragraph 18, what is your reply to that paragraph 18? It's a simple matter. It takes 2 minutes.
My-
For you, you are making it confusing and yeah. Does it take so much of time for this matter?
885 item.
By the time you have said so much further, this order would have been finished and the next matter would have also been finished.
I deeply-
We impose a cost upon you of 10,000 upon you, not on the client. You, for making all this, taking a precious time of the court. Yes, what do you say about paragraph 18?
My lord, kindly see page number 58, my lord. In this regard, my lord, they stated that 8518, the petitioner or defendant have filed the written statement in defense along with the petitioner.
Huh?
But they have filed on 12/12/18, my lord. Page
Where?
number 58.
Eh?
Annexure 8, my lord.
12,
When 12/12/18, my lord.
how do you know?
They have written
Where?
in the page number 58, my lord.
Where is it mentioned? No, here, written objection filed on behalf of so and so, accepting the written statement filed by Iman in response to the petition. Accordingly, the plaintiff had known on Iman. Where? Ought to have rejected by this court and cost of petition upon is liable to be rejected, including them from filing and then having due regard to the mandate of law. Where is it mentioned? By 2, get a date from the court when you have filed it. By 2, you get the details. Don't come up in this manner. Else, cost of 10,000 upon your client and 10,000 upon Mr. Nandi, spoiling the time of. Now also saying 58.
885.
That is what I said. Whether it is 85 or 58. You just said 58 again.
885.
Where?
85 we have.
How do I know?
My lord, in our petition, if lordship kindly peruse the page number 9, there also we have mentioned. Page number 9. Para number 17, may kindly peruse. That the defendant, petitioner defendant has received the documents on 8,018.
Para number 18.
17 in the middle.
18.
17, and in the 18 we have specifically mentioned that on 8/5/2018 we have filed the written statement in defense along with petition to accept the state joint.
Yes. Yes, Mr. Counsel, what do you have to say? Mr. Kumar, what do you have to say?
Kindly see my lord, page number 66.
Huh?
Page number 66, ma'am.
Yes.
This is the order of 21/1/18, my lord.
Hmm.
That is the bottom from my record shows that the proper copy of the document in the set were filed earlier meant for dependent number 3, 5, 6, 7, 8, and 9. Considering this aspect, the applicant, the petition number 376/18 concerning furnishing the copy of reject. However, prayer for time to file written statement is allowed and mandatory period is 90 days will be counted from 13/12/17.
Then
Thereafter, my lord, another order is, my lord, page number 69, my lord.
64.
Page number 69, my lord.
Yes. 94, no, 53.
9/4/18,
53 2018, page 64. Because here this order says next date is on 53.
my lord.
The next date is 53.
Page number 64,
The
my
next page is on 6/3 2018
my lord.
for WS.
The dependent seeking time to file WS, my lord.
So then it is over by on 6/3. Then they did not file it.
My lord.
Then again another 90 days. They filed another application on 9/4.
Yes, my lord.
9/4 is for
9/4/18 is page number 69.
then you see page 70. See in petition number 1798. 69. Okay.
My lord.
Kindly come down. Okay, page 70. Now, prior to the amendment of CPC so and so did not contain the limitation of so and flouted so and so. Moreover, the grounds shown by the defendant for not filing the written statement today cannot be meaning brought within the exception, rarest of rare case, to get them the benefit. So on 9/4, the court proceeded against them,
My lord.
not to file the written statement.
My lord.
Then they file it on 8/5.
8, Thereafter, my lord, the matter was listed on 5/6/18, my lord.
Okay, we allow you 25,000 cost.
Right.
Absolutely no.
Right.
Cost has to be given. There, otherwise, I'm not satisfied. You didn't show any good reason. What's your good reason?
My lord. Kindly, if the lordship reads the page number 64, where the learned trial court himself has mentioned that we have received it on 8/2018. 8/2018. The page number 64 type copy I have order dated 5/3/2000. There it is specifically mentioned, change received on 8/2018. And so thereafter, my lord, that this thing. Thereafter, my lord, we have filed it within 88 days from the date of receipt of the claim.
What is your right?
My lord.
What is your right to have 90 days?
My lord, it is the extended time.
So, extended time depends on the discretion.
My lord, that is from the date of receipt. Hence, this 6/3 that my learned friend has mentioned, that that is not for us, just for the dependent number 10 and 11. We have filed it within, my lord.
But we don't know that you have filed it on 8/5.
My lord, our this petition number may kindly be 2313.
This is certified copy we have annexed to this petition as annexure number 7,
Page,
page number 56. And type copy is, my lord, as page number 50.
what is the order passed here?
My lord, it is on an off day because after 9/4/2018, then next date was fixed on 5/6/2018, and before that we have filed before the next.
And why did you file an amended petition? Why did you file an amended petition here?
Amended petition we have filed because in the petition we can state that it is 9/4/2000. This order we have
And the amended petition does not enclose, there is no enclosure. There is no enclosure. So, if the amended petition does not have any enclosure, can we treat this application? As of now, once you file the amended petition, we cannot look into the earlier document. So does this document have any documents? There's no impression out there.
There is no additional document we have filed.
No. Can you file a petition on affidavit without documents, which was a part of it, and you say that there is an enclosure out there? Did you enclose anything? Copy of the petition? Then it's in violation to the Guwahati High Court rules. So we dismiss it on that ground.
My lord, the
This is an application under Article 227 of the Constitution, challenging the orders dated 21/2018, 9/4/2018, and 23/9/2018, passed by the learned Court of the Civil Judge number 1, Kamrup Metro at Guwahati, in title suit number 446/2017, whereby the learned trial court debarred the petitioners herein, who are the defendant numbers 3, 5, 6, 7, 8, 9, and 9, from filing their written statement, as well as also had rejected the application filed seeking review of the order dated 9/4/2018. This court have perused the documents enclosed along with the instant petition, as well as also the orders which were passed by the learned trial court. In terms with the order dated 21/2018, the learned trial court observed that the records show that the copies of the documents in 7 sets were filed earlier to be meant for the defendant numbers 3, 5, 6, 7, 8, and 9, and accordingly fixed 5/3/2018 for filing of the written statement. However, on 5/3/2018, the defendant numbers 3, 5, 6, 7, 8, and 9 again sought for adjournment by filing a petition bearing number 1128/2018. And the learned court observed in the said order that a copy of the plaint was received on 8/2/2018. Thereupon, the case was fixed on 9/4/2018 for service report and written statement by the defendant numbers 3, 5, 6, 7, 8, and 9. However, on 9/4/2018, as the written statement was not filed by the defendant numbers 3, 5, 6, 7, 8, and 9, the learned trial court debarred the said defendants, who are the petitioners herein, from filing their written statement. On an off date, a petition was filed on 8/5/2018 by the petitioners who are the defendant numbers 3, 5, 6, 7, 8, and 9, stating inter alia that the written statement has been duly filed and to accept the same. The said petition was numbered as petition number 2313/2018. However, it seems that the learned trial court did not take note of the said petition. On 5/6/2018, rather took cognizance of the petition filed on the same date, bearing petition number 2314/18 under Order 47 Rule 1 of the Code of Civil Procedure, read with Section 151, praying for review of the order dated 9/4/2018. By the order dated 23/9/2019, the said petition seeking review was rejected, and it is under such circumstances the instant petition has been filed, challenging the orders dated 21/2018, 9/4/2018, and 23/9/2019. I've heard Mr. D. Nandi, the learned counsel, appearing on behalf of the petitioner, and Mr. V. Kumar, appearing on behalf of the respondents. From a perusal of the petition filed on 2313/2018, which was filed on 8/5/2018, it is seen that the written statement was filed by the petitioners herein, who were the defendant numbers 3, 5, 6, 7, and 8 on 8/5/2018. It is also seen that in the order dated 5/3/2008, it is also seen that in the order dated 21/2018, the petition was filed by the defendants, stating inter alia that the plaintiff had not furnished copies of the annexed documents for which they could not prepare the written statement. In the order dated 5/3/2018, the learned trial court duly acknowledges that a copy of the plaint was received on 8/2/2018. And thereby fixed 9/4/2018 for the written statement of the defendant number 3, 5, 6, 7, 8, and 9. However, on 9/4/2018, as the written statement was not filed, the learned trial court proceeded of the learned trial court held that the period of 90 days was over. However, if this court takes note of the order dated 5/3/2018, the learned trial court categorically observed that a plaint was received on 8/2/2018. And as such, filing of the written statement on 8/5/2018 was within the period stipulated under Order 8 Rule 1 of the court. Under such circumstances, this court interferes with the order dated 9/4/2018 and directs the learned trial court to accept the written statement so filed by the defendant petitioners, who are the defendant number 3, 5, 6, 7, and 8. Eight and nine. First, the consequential order, the order dated 23/9/2019, which is only an order seeking review. The order dated 23/9/2019 therefore loses its significance, taking into account that the order dated 9/4/2018 has been duly interfered with. This court further takes note of that by an order dated 19/2/2020, the further proceedings of title suit number 446/2017 was stayed. The said order stands vacated and the parties who are duly represented are directed to appear before the learned trial court on 10/6/2024. The trial court shall proceed with the adjudication of the suit in accordance. But Mr. Nandin, next time, amended petition, you can't say that you don't know. Yes, did you get it?
Yes, sir. 96/4
There's a 96, 97.
96.
There it categorically says the 96 one. No?
Yes, sir. Para 5 is sectionated.
Yeah.
Apart from that, if your lordship sees there, another aspect, because I did not find any precedent in that regard. Rule 6C of Order 8, your lordship. The power to exclude the counterclaim is not unfettered in my assessment.
This is an application. The instant application heard Mr. B.J. Mukherjee, the learned counsel, appearing on behalf of the petitioner. The instant application has been filed challenging the order dated 15/3/2024, passed in title suit number 46/2023, whereby the learned trial court had trial court did not accept the counterclaim filed by the defendant numbers 1, 2, and 3, thereby giving the liberty to the said defendants numbers 1, 2, and 3 to file independent suit in connection with the subject matter of the counterclaim. The learned counsel appearing on behalf of the petitioner submitted that the learned trial court completely failed to take note of judgment of the Supreme Court in Jagmohan Chawla and another versus Dera Radha Swami Satsang and others, reported in 1996, 4 SCC 699, wherein it has been categorically observed that a counterclaim need not relate to the original cause of action but can be made on an independent and different cause of action, even on the one which accrued to the defendant after the institution of the suit. The learned counsel further referred to the paragraph number 6(5) of the said judgment. And more particularly to the relevant portion of the said paragraph. Which is quoted here in below. Huh? Did you file the counterclaim?
Yes.
So it will amount to rejection. 227 is not maintainable.
If the word that is used is
Whatever it is returned is rejection.
I have thought about that, but under 6C it is that.
Wait. This court had perused the impugned order dated 15/3/2024, passed by the Court of the Civil Judge Junior Division, Kokrajhar. And from the perusal of the said order, it appears that the said order is in conflict with the settled position of law as above noted by the Supreme Court. The learned counsel for the petitioner submits that this judgment was not placed before the learned trial court. It is also the opinion of this court that had the judgment been pointed out before the learned appellate trial court, the trial court would not have passed this order. Considering the above, this court closes the instant petition, thereby giving a liberty to the petitioner to file a review application before the learned trial court within 30 days by Aji ki tarikh 13 by next date. Any idea?
22/5.
For by 31st of May. By 31st of May 2024. So, if such review application is filed within this period, the same shall be construed to be filed within the period of limitation. And the learned trial court shall duly take note of the above judgment and pass appropriate orders. With the above, the instant petition stands closed. I think that is the best one. Issuing notice will stay. And the other thing is you have a big problem. It is a rejection. Yes, what is this?
Seeking an adjournment of the matter for date of the hearing.
Leaks for admission hearing.
Any
DK Sharma. Section 9.
Yes, ma'am.
Stay.
Yes,
Stay is going on.
yes. Initially 16/3/2021.
Proceedings under 226 are maintainable against the Yes, now 227.
Yes, lordship has converted it.
This is a AP.
It's a under
We are-
226 now, my lord.
So
It's a
we have to
revision.
call for the records.
Lordship had, my lord, earlier. Yes, my lord, lordship called for the record, my lord.
We call for the records?
Yes.
No.
By order 14/8/2023 in view of the judgment of LIC versus Nandini.
No, I have not called for the record. I have converted this petition.
Converted, my lord. Interim order to continue. And otherwise, my lord, this on the face of the page 35 of the order, my lord.
Hmm?
Page 35 of the impugned order,
Hmm.
my lord, second paragraph in between, my lord, lordship, the learned court has considered this. On the other hand, I have gone through the annexure 1 Sita of this disputed land, which shows that the land belongs to the railway. My lord, this Sita copy, the railway enclosed that, my lord, in respect of
Yes, what right do you have over the land? What right do you have over the land?
After recite here from long back.
So what?
Establishment of the railway headquarters.
Huh?
Before the establishment of the railway, I am residing.
Since when?
Since lordship, 75 years lordship. The establishment of the railway headquarters is in 1968. But before that, I am residing there. Also, lordship.
One is 38 years old and you are staying for 75 years.
Lordship,
in the judgment, page 34 is the malad ground, air ground. Page 34. They have holding number, electricity connection, ration card, GMC tax. It is submitted that the appellant has no immovable property, strip residence as the economically backward class. It is submitted the appellants have occupying disposal without any disturbance from any corner. And he has also obtained electric water supply connection in his suit premise. On so and so, the respondent to issue show cause notice. Only
Then
that
the
electric, this will.
schedule of the land is also not properly mentioned. It's another ground.
These are not grounds to be taken here.
No, so we'll take the date, my lord, if for here, he has some problem.
Who?
It's our big the matter.
Near, you don't require senior. He knows how to argue. And why everybody, did you file one appeal? All of you? File one appeal? Sure?
Yes.
How was the appeal maintainable?
Different notice were issued, my lord,
Then?
and different orders, eviction order
Then?
under section 5. First,
Did all of you stay for 60 years?
No.
It's a government land.
Lordship.
And when was the settlement given to the railways? Where is the land?
yes,
And why do you require it?
my lord, for water pump, for water supply, my lord.
Okay.
This is
This,
the my lord, Sita copy.
this court having taken note of the instant application. It is filed challenging and order dated. Sixteen 2020 in Miss Appeal number 25 of 2017. Is of the opinion that for deciding the state instant petition, the record of Miss Appeal number 25 of 2017 would be required. Taking into account the above, is the matter again on 18th of June 2024. Steps. The registry shall forthwith follow the records of Miss Appeal number 25 of 2017 from the court of the additional district judge number 1 Kamrup Metro at Guwahati, so that on the next day the said records are available.
Problem.
Much of that.
May I praise the Lord?
Hmm.
It's the second appeal matter. There's this case before going to second matter, the substantial question. The fact matter here, I filed suit matter in respect of path matter for use of path matter. Now what happened? The suit was dismissed. Appeal decided in favor. But only thing, my lord, in the decree, my lord, that obstruction which was there in the plain, by removing the obstruction, that was not mentioned. So I filed an application under section 151 for that. So that became part of the decree, but that obstruction was not there. So in that way, also decree has been passed in my favor. The decree becomes non-executable, my lord, because that obstruction, removing obstruction from the path, that has not been mentioned.
The appeal was allowed.
Yeah.
So why you are filing a second appeal?
Well, there is no other
You filed an 151 application.
152, yeah.
152.
Yes.
If 152 is not given, then don't you think that you have to
No,
come on
but 152 given that became part of the decree, my lord. But that,
Understood.
yeah, specific word
Understood.
is not.
But problem is, you want the relief on your favor.
Yes, but
This RSA, if I admit it, it will go for 6.
yes, I understand. But since that became part of the decree, my lord, 152, my lord, application, my lord, can you see, my lord, that at page, just showing page 52, my lord, the decree, my lord. Okay,
No. In view of the above, the appeal prepared by the appellant is allowed and the impugned judgment is to be set aside. Prepared that in view of the admission made by the witnesses regarding the executive, it can safely it is both of remand. Then
Well, page 52, my lord, the decree, my lord,
the decree has been passed.
after a quick question, you take down below, my lord. In view of the discussion, the appeal preferred, the appeal allowed, the impugned judgment decree power of the suit established schedule within schedule 1 is common path plaintiff and defendant. The defendant shall not disturb the peaceful enjoyment of the suit path by plaintiff in any manner.
What is this order?
Then
This
my lord,
order,
then my lord,
2019.
Yes.
2/1/2019.
then my lord, page 54, my lord. Immediately on that day, my lord, we file application under section 152.
That I've seen.
Yes. The last part, that particular word is not there, removing
Where?
obstruction. That is there on record, my lord.
Where?
That is, my lord.
Where is the impugned obstruction to be removed?
Yes.
Where
That
is your
part,
plain?
yes, in my plain, my lord. Plain, my lord, page 7, my lord. The prayer is there, my lord, page 11. Of the memo. Start from 10.
I have no right title over the suit to disturb the suit for the of mandatory injunction that is
But that is coming in the finding also, but
Huh?
see, it is coming in the finding also, my lord. What I found, my lord, in the judgment also.
There's
But
no
see,
finding.
No, but that discussion is there, my lord. The defendant and the plaintiff both deposed, my lord, regarding this, my lord.
No, where is the finding as without that mandatory injunction?
Yes, my lord, that is
The fact.
that is appellate court judgment, page 44.
The A2 Chaudhary, the problem is, I can admit it,
Yes, it will take.
it's no problem. But once I admit it, it may be a complication. The judgment is horrendous, very badly written.
Yes, sir. So No, they did not file
They
any.
didn't know nothing. Why the trial court judgment was set aside? There is not a single mention.
Yes, exactly. The point by discussion is also not there.
Huh?
That is actually is valid to under the order 41 rule 30. But since it is in my favor, I did not go to that extent, my lord. My point is that appellate court judgment, since it is allowed, my lord, by prayer of the suit filer.
See the problem. Okay, what is your substantial question of law?
Substantial question, my lord, it has become very difficult because it is in my favor. So perversity is the main, only thing, my lord.
No, there is no perversity. No, the question of perversity.
Page 4. Because
It
since
is the
it is
question
there,
of we are to obtain. These are not perversity. It will be a case that we are to assume that your prayer for mandatory injunction has been rejected. That would be a yeah. No. This is an appeal. It's heard Mr. A.U. Chaudhary, the learned counsel, appearing on behalf of the appellant. This is an appeal under section 100 of the Code of Civil Procedure, challenging the order judgment and order dated 16/5/2018, passed in title appeal number 24/2017. The appeal is admitted by formulating the following substantial question of law: whether the learned first appellate court, while allowing the appeal, was justified in not granting the decree of mandatory injunction when the learned first appellate court had come to a categorical finding that the
page 50, my lord, last part of
age
page 55.
of the categorical finding that the appeal prepared by the appellant, that is the plaintiff, prepared by the appellant herein, is required, is allowed, and the judgment and decree passed by the trial court was set aside. Issue notice making it returnable by 6 weeks. Step be taken by way of registered agent.
All right.
Instead, you should file a review there. It would have been easier for you. If you don't do it, it will go for a year, and one fine day it may go against you. This is a very dangerous point you have put. Because once this court, because you see, the exception number 3, exception number 5 to the section 11, when the court passes an order and does not grant the relief, it will be deemed that the relief has been rejected. Doing it is a different thing, but you will have a
Well,
big problem.
Once the appellant came, my lord, we had a talk with the advocate at Hailagat. They refused to, they said, "Oh, this is, we are not going to do anything."
No, simple thing is that thing has to be proved. The review. In fact, when the judgment is passed, question, whether the judgment and decree, whether the learned first appellate court, whether the judgment and decree passed by the learned first appellate court is in consonance with order 41 rule 31D of the Code of Civil Procedure 1908, taking into account that the learned first appellate court failed to state the release to which the plaintiff was entitled to, plaintiffs of the appellants were entitled to, upon the reversal of the judgment passed by the learned trial court.
All right.
I think this is the issue we should put. The second one will be better.
Yes.
I don't put the mandatory in it will have a difficult problem.
Mandatory will be,
31D. প্রথমটো নালাগে। Yes, Mr. Purkayastha,
Lordship concurrent finding.
without you, I have allowed two of your matters. Yes, yes.
Lordship, yes. Lordship, this appellants filed another appeal also, second appeal, Lordship has admitted the application.
I have admitted.
Yes.
Then-
Appeal number 1 and 2 at
In this case, I am filing Okalat number 2.
Same question.
Same question will be
only
possibly exhibit.
PW in place of PW2, it will be PW1.
Huh?
PW
Exhibit also will be different.
exhibit 6.
Where PW2? I have not
PW.
mentioned. PW, it will be PW1.
One.
It
Exhibit
means
6.
na koi দিব.
Exhibit
It's
3 only.
a different suit, na?
Different.
এইটো হ'ব, এইটো একেই অৰ্ডাৰটো এনেকে কৰি দিব। Judgment and decree dated,
Same. Lordship. Only title
past
appeal
in title appeal number
18. Earlier was 19.
18.
Was
was
23,
dismissed.
it will be 21.
Thereby confirming the judgment and decree dated
24. Dated 29/9/2018. Same.
past in the learned Munsil Lakhipur Kachar, whereby title suit number 1 was dismissed. Number
Title number 23 earlier.
20 earlier was 23,
Now
dismissed
it will be 24.
24/2014 was it. He is admitted by formulating Iman whether the deed of sale bearing deed number 1057 dated here was vague document by relying on the evidence of PW1
Yes. Sir.
without taking into account the documentary evidence, that is more specifically exhibit 2.
Exhibit will
notice.
be 3, my lord.
Huh?
Exhibit 2.
No, no, it is.
What the
Yes.
Exhibit 2.
Exhibit 2.
এখন এনেকুৱা type কৰিব।
Two more here. Lordship. Respondent number 2 has expired. Our detailed
They are already party.
they are already part. Unnamed start. Unnamed start. Are already part 4 and 5. Respondent number 3. In that case,
Who? Respond number 2 is dead.
3 Lordship.
3 struck off.
3.
Struck off already by the order dated 1/5/2024 in IC. 3 struck off. So it will be 1, 2, 4 and 5.
4.
You appear for them.
Yes.
Mr. H does it issue notice করব না লাগে। Mr. H does appears on behalf of the respondent number. Issue notice না লাগে। Number 3 to লিখিব Mr. H 3 আর 4 to না লাগে। Mr. H does appears on behalf of the respondent numbers 1, 2, 3, 4 and 5.
4 and 5.
Why do you need a performer respondent? Mr. S.D. Purkayastha, the learned counsel appearing on behalf of the appellant submits that the performer respondent number 6, 7 and 8 did not participate in the trial or in the appeal proceedings. He submits that the name of the performer respondent number 6 to 8 may be struck off. Taking into account the above, the names of the performer respondents number 6 to 8 is struck off. In view of the above, the service is duly complete. The registry shall call for the LCR and list the matter for hearing immediately there.
Both the matters will come together.
Huh?
It will take
We'll see later on. Other one, other has service problem, na?
Yes, sir.
8 to 3, 4, 5, 2, কোথায় দিব, হ্যাঁ? খালি 8 to 1 and 2 to দি, তার ভিতরে কি?
But regarding arbitration respondent number 4 and 5.
And you are appearing. What is the order challenge?
I am appearing for respondent number 1 and 2.
4 and 5
6,
service is not complete.
Yes,
Not
yes.
7, 8
2 to
government.
2023.
Government is there, but 6, 7, 8.
You are appearing?
Lordship 1 and 2.
So what is wrong? How is it wrong?
Arguments.
The amendment should have been allowed, only the date
my lordship.
How
Date
does it matter? He has used the document. The
Yes,
sale
sir.
deed is already there on
Sale
record.
deed already there on the record, but date is
only lordship at our argument stage, lordship.
Oh, this is a small however, it can be done by hand. You see, the evidence has been given.
Everything.
If he
done.
says ABCD also hardly matters in view of 91. It is the document which will speak. The document is that. Oh, these amendments should have been. They can be how many in how many places you have put this wrongly?
In several places, maybe like, we have mentioned it in the year 2014 in our
Your
written statement.
lordship would be pleased to see my petition.
No, yes. Petition is where?
Place.
Huh?
2 place.
3 places.
3 place.
Where? Amendment of paragraph 4.
Paragraph 4 and 11.2.
Huh?
That is the 11.2 is the prayer.
Okay. 4 times.
Paragraph
Okay.
4, lordship.
Paragraph
From
4 and
27 to 22. We allow this
Lord.
may take the learned counsel appearing on behalf of the petitioner. Our counsel appears on behalf of this is an application challenging the order dated 14/9/2023 passed in midday case number 114 of 2014 arising out of statute number 137 of 2014 whereby the amendment so sought for in the plain of a typographical error in mentioning the date of the registered deed of sale was thought to be corrected. The said application was rejected, taking into account that the same was filed at the time of arguments. This court have duly taken note of that in the plaintiff have categorically mentioned the deed number as 365/12. However, in paragraph number 4 of the claim and in para 11 Roman 2, the date was wrongly put as 27/2/2012, which ought to have been 2/12/2012.
No, lordship. Wrongly said 2/2/2012, it ought to be 27/2. And
So,
paragraph
go to,
11, 2 and 3.
2/2012, but wrongly put as 27. Should have been 27/2/2012, but wrongly put as
27/2/2012 is correct.
should have been
Wrongly put as
27/2/2012, but wrongly put as 2/2012. So the said this court have also taken note of that the said deed of sale have been duly exhibited, and the same amendment so made does not in any manner change the nature and character of the suit, or in any manner affect the adjudication, cause any prejudice to the respondent. Under such circumstances, this court permits the application being meets case number 114 of 14 and allows the application being meets case number 114 of 2020.
2023.
23. Thereby allowing the amendment of court. This court further directs the solicitor of the court of the Munsif number 2, solicitor or the solicitor. Should you direct the solicitor or the courtmaster? Solicitor. The solicitor of the court of the Munsif number 2, Hubri, upon production of the certified copy of the instant order to make the necessary corrections in paragraph number 4 and paragraph number 11, Roman 2 of the plain by hand. Thereby, the deed of sale, the date of the deed of sale be mentioned as 27/2/2012 instead of 2/2/2012. On the basis of the correction, the trial court shall thereupon proceed with the arguments of the case.
Lordship, in two places, paragraph number 11, Roman 2 and Roman 3.
He's
It-
not asked for Roman 3.
Roman 3 is also
Page
there.
27, kindly see.
Roman,
He's only asked for
Roman
11.
3 is also there, Lordship, a decree for cancellation of the sale deed, so dated. such. There is also mistake, Lord.
But he's not asking, what do I do?
And
These are
Lordship,
too
now
small there.
the,
In
now the
11,
court has
11,
become
Roman
civil
2
judge
and
junior.
Roman 3. 11.
Lordship, civil judge junior division now. Munshi.
Civil judge union. This
11.
court taking into account that by the order dated 18/12/2023, there is no stay, na?
There was a statement.
Stay, Lord.
Yeah, taking into account the parties are taking into account the above order, vacates the order dated 18/12/2023 and directs the parties to appear before the trial court on 10/6/2023, 24. Full stop. Prior to that, by 3/6/2023, 24, the plaintiff shall produce the certified copy of this order before the solicitor of the civil judge number 2.
Lord, 11, 3 also taken into consideration.
I said 11.
Allowed, much of it.
Should be thankful to that. The LCR has not been received. The LCR has not been received. This is a second appeal of the year 2002. The registry shall forthwith take appropriate steps for requisition of the LCR. And list it for hearing immediately upon receipt. What is this arbitration appeal?
Rental lawsuit is matter become infructuous. Therefore, honorable court psycho order is arbitrator was appointed lawsuit and he has passed the award. Against the award lawsuit, they have preferred an appeal lawsuit.
Appeal where?
Before the second section.
What is this?
Here lawsuit, they are challenging the order of lawsuit, but jurisdictional part of the lawsuit, spiritual jurisdiction part
of
the arbitrator lawsuit.
How can they challenge here?
Lord. Section 9 application was their lawsuit.
No, this is section 34.
Lord, they have particular debt contract lawsuit. They preferred one arbitration petition before the Honorable High Court and lawsuit against one is section 11 petition is on lawsuit. But that particular petition Honorable High Court has directed us to appoint a lawsuit sole arbitrator. Accordingly, the Railway Authority appoint the arbitrator and he has passed the award lawsuit. Against the award, they have preferred an appeal lawsuit under section 32.
What is this?
This is becoming infructuous lawsuit.
Why? This appeal is directly against what? You filed a section 9.
Lords, they have filed.
Filed a section 9 application before the Arbitration and Conciliation Act. Then that application was Yes, what do you say? Infractions? No, either dismiss, no instruction. You say that now section, the arbitrator has already passed the
Already
award,
passed the award, Lordship.
and as such, an appeal has been filed against that.
Lordship, Lordship, Lordship.
Section 34 has been filed.
Lordship, this is the order, Lordship, under which the arbitrator was appointed. This is our High Court's order.
So, no, against that 34 has been filed.
Lordship,
Who has filed them?
they filed. Lordship.
So there it is filed. So then they have to move and section 9 or whatever maybe they can do. It's
But
a
this
different thing.
petition,
But it
Lordship,
is-
this petition, Lordship, nothing.
This is an appeal filed under section 37 of the Arbitration and Conciliation Act 1996, challenging the order dated 31/10/2008, passed in Miss R case number 565 of 2008 by the Court of the Learned District Judge Kamrup Guwahati. Mr. K. Gogoi, the Learned Counsel, appearing on behalf of the railway, submitted that pursuant to the order passed by this court on 31/10/2008, an application was filed under section 11 of the Arbitration and Conciliation Act 1996 before this court for appointment of an arbitrator. This court, by an order dated 11/6/2010, directed the railway authorities to appoint an arbitrator to resolve the dispute between the parties. In accordance to that, in pursuance to the said order, the railway authorities duly appointed an arbitrator, and the arbitrator have already passed an award which has now been put to challenge under section 34 of the Arbitration Act 1996, Arbitration and Conciliation Act 1996. So, taking into account the above, this court finds nothing further remains to be decided in the instant arbitration appeal, for which the instant arbitration appeal stands closed as in practice. Good.
In this case, petitioner, current counsel for the petitioner withdrawn his wakalat number. Kindly peruse order dated 29/1/2020.
He cannot, he says that here submits that he has lost his contact with the applicant petitioner and wants to withdraw. Alanke has also filed an affidavit. It is also submitted that he has taken steps against the petitioner. The ID card is not given. What is this application for?
If the original CRP is regarding, they have challenged that their prayer for amendment was rejected. In the meantime, Lordship, some respondent has died. Respondent number 59.
Amendment of what?
Amendment of plain Lordship.
Huh? There is a stay?
Yes, Lordship, the stay. 2008 matter.
There is a stay.
There was
The
a
stay has been vacated? No.
No, Lord.
No, tell me, what is this AA for? Miscase for? There are two miscases.
Miscase for regarding substitution of respondent numbers. Some respondent died Lordship in the meantime. Respondent number 594. They have filed substitution petition and delay condemnation petition. That was also pending, Lord.
And that has been pending.
Lord.
What has happened to the suit? Any idea?
Lordship.
Suit?
Suit regarding right title interest.
What has happened to the suit?
Suit is pending, Lord.
Where? Why? There is a stay.
Stay, Lord. Their prayer for amendment was rejected.
Amendment was rejected and the suit has been stayed from 2008.
Yes, sir.
Goodness. Dismiss this. It can't remain like this. It has been brought to the attention of the court that on 29/1/2024, case 670, case 670, that the earlier set of counsels appearing on behalf of the applicant have retired. Therefore, notice has been issued. But then also the applicant is not represented. Considering the above, the instant application stands dismissed for non-prosecution.
Comment also there, one.
Wait. Now, what is he asking for? Let us see. Amendment of the plain. What is this amendment?
Some deletion of define number 1, 2, and 3 from the cost side. Let me kindly peruse the impugn order, page 35, para 9 in turn.
Nine 1/2000. Economic. None has appeared on behalf of the applicant on call. Petitioner Mr. Appears on behalf of
F1 number 4A to 4E.
4A to 4E and Mr.
ER Gogoi, 1 to 3.
ER Gogoi appears on behalf of the respondent numbers 1, 2, and 3. So this is an application file under Article 227 of the Constitution challenging the order dated 29/1/2008, whereby the application seeking amendment of the plaint was rejected. This court had duly perused the said application, said order dated 29/1/2008, and we allow this. What is there? It is a simple thing. Steps have not been completed. SR. 16 years the matter is pending like this. We allow it. You say against somebody again, whatever, it's something they only ask what is the plan. Submitted that although the plaintiff implemented the circle officer Sopua, no relief has been sought against him. Again, while drafting the suit in para 14, the relief for imperfect power was drafted, impeding the defendant's state of Assam, the deputy commissioner, and the concerned as defendant, which was finally omitted due to reason that no such separate relief is needed to be granted. But due to typographical mistake, the same remained in the plain and in the oversight of the did not detect the same. Appearing on behalf of the refer to the written statement. And there is no justifiable ground to file the petition. He submits that the amendment for introduced are not necessary for real question. The record is reviewed between the State order dated 29/1/2018, and from the perusal of the state order, more particularly paragraph 9, 10, 11, this court is of the opinion that the said order does not require any interference, more so in exercise of the jurisdiction under Article 227 of the Constitution. This court further takes note of that the learned trial court duly takes note of the contents of the plaintiff and is of the opinion that the amendment which have been sought for is already there in the plaintiff. But this court also is of the opinion that the perusal of the plaintiff reveals the said picture. Considering the above, this court finds no ground to interfere with the order dated 29/1/2008, for which the instant petition stands dismissed. The stay order so passed by this court on 12/3/2008 stands vacated, and the parties herein are directed to appear before the learned trial court on 14th of June 2024. This court, however, takes note of the fact that the petitioner is not represented, and as such, the learned trial court, before proceeding with the suit, shall issue due notice. None appears on behalf of the applicant for call. This is an application for condoning the delay of 240 days in filing the second appeal against the judgment and decree dated 9/2/2011 passed by the Court of the Civil Judge, Nagaon, entitled Appeal number 24 of the 2006. Taking into account that none has appeared on behalf of the applicant, The instant application stands dismissed for non-prosecution. Consequently, the regular second appeal so filed against the judgment and decree dated 9/2/2011 passed by the Court of the Civil Judge Nagaon in title appeal number 24/2006 cannot be entertained. Yes, what is this?
But this matter, they settle the matter with the lordship as per their instruction.
Yes, then settle.
No, I do not know, Malcha. I have to take instruction.
It's a 2013 matter. Because the Section 5, Section 6.
Six.
Okay. You filed it.
No,
Tell me, what is your case?
But actually, I am here today.
No,
As they
these
have already-
matters of 2013, I cannot keep it like.
If they have settled lordship, they have taken back all the files of petition stuff. On the last of it, there is an order there to lordship submit the compromise thing. It's 24 and 25 are relevant.
Oh, yeah, record by. What to do? This is an application under section 115 of the Code of Civil Procedure 1908. Assailing the judgment and order dated 31/7/2013, whereby the suit filed by the plaintiff under section 6 of the Specific Relief Act 1963 for recovery of possession and permanent injunction was dismissed. This court had duly perused the judgment, impugned judgment and order, and from a perusal of the said judgment, it revealed that the learned trial court have duly taken note of the evidence on record and had come to a categorical finding that the plaintiff could not show that the plaintiff was in possession of the suit land. Consequently, this court have also perused the materials on record, the records, wherein from which this court does not find that the learned trial court have committed any jurisdictional error in dismissing the application under section 6 of the suit and in dismissing the suit. Accordingly, the instant petition stands dismissed by confirming to the judgment and decree dated 31/7/2013, passed in title suit number 27/2011. This court, before concluding, this court, however, makes it clear that the said judgment so delivered shall not preclude the plaintiff to avail other remedies and as is otherwise available in the law. The registry shall return the LCR. Yes, what are you challenging?
My lord, the impugn order.
Page. Written statement.
No, man. What happened, my lord?
Which is the
My
impugn
petition
order?
under order 7 rule 11 was rejected against the, I have appealed to your court.
Your application has been rejected. Why?
Under order 7 rule 11 D, my lord, at page 119. My lord, what happened, my lord? I am in the position of that suit land from 1955. My grandfather, he purchased the land. My lord, in 2000, my lord, I have taken the electricity connection, my lord, and I have constructed some room used for school purpose. Then what happened? My neighbor, he managed to convert the land into periodic patta. At that point, these plaintiffs, they have mutated their name. We have given objection, and then he filed a suit 29 of 2011. The wherein I have filed WSN counterclaim, and in the WSN counterclaim, I have stated all these facts along with the fact that the boundary was wrong. It was withdrawn. Then he filed this suit 38 of 2013. Here, my lord, I have filed this petition which was rejected.
What is your ground?
My lord, my ground is adverse position.
Huh?
And we are in possession of the suit land.
So what?
since
This is a question of proof.
1955, man. From the time
That
of
is
my
immaterial.
grandfather, man.
Where is your petition? In the matter of an application. Suit for what? Recovery of possession.
Eviction.
Recovery of possession. So it's 12 years. Then why are you saying 3 years? And that is only ground. Withdraw, dismiss, which one? Is there a stay? My goodness. No, this is an application. You are appearing.
1 and 2.
This is an application. And we don't put it 227 because people will laugh. We make it 115. This is an application under 115 of the Code of Civil Procedure 1908 challenging the order dated 24/3/4/2014 and passed in title suit number 38 of the 2013, whereby the 38 of 38 of 2013, whereby the application filed for filing of the for rejection of the plaint was rejected. It is relevant to mention that the said petition so filed has been numbered as petition number 124 of the 2014. This court has perused the plaint, and from a perusal of the plaint, the plaintiff has sought for a decree for eviction of the defendant from the suit land and for delivery of cast possession to the plaintiffs. The suit is based on title, isn't it?
Yes.
And as such, the period of limitation would be in terms with Article 65 of the Limitation Act, of the Schedule to the Limitation Act, which stipulates 12 years in the circumstance the respondent, the defendant, allege adverse possession. It is also relevant to take note of that a suit based on title does not have a period of limitation. It is only when the defendant claims adverse possession, the period of limitation is 12 years. Full stop. The question of limitation, the question of claiming adverse possession is a question of fact which the defendant has to prove, plead and prove. Under such circumstances, in the opinion of this court, the learned trial court was justified in rejecting the said application by the impugned order. Accordingly, the instant petition stands dismissed with cost quantified at rupees. You have paid the suit for 10 years. 10,000 to be deposited before the learned trial court on the next date as this court so fixes. The interim order dated 12/9/2014 stands vacated and the parties are directed to appear before the learned trial court on 14/6/2024.
These are very poor people.
Poor people? You have poor people, you have stayed for 10 years by getting a stay. Luckily, today I got it out somewhere in orders. Isn't it, Mr. Sharma?
They allowed.
They allowed you? What to do? With so many matters. This is another old matter. All this, somehow people have been getting all these old matters before me only. Eh? Yes, next.
Problem.
Who is appearing? None appears on behalf of the petitioner on call. It is also seen that on various occasions the petitioner had sought for time for taking steps. But no steps have been taken. So, apart from that, necessary applications which were also to be filed as have been recorded in the earlier orders passed by this court have not been filed. From the above, it reveals that the instant petition, the petitioner is not interested to pursue with the instant remedy for which the petition stands dismissed for default. This court, none appears on behalf of the petitioner on call. On various occasions, directions have been issued to take steps by the Lozuma court upon the respondents. However, no steps have been taken. It seems that the petitioner is not interested in the instant proceeding, for which the instant petition stands dismissed for non-prosecution. The interim order dated 16/10/2015, whereby the operation of the order dated 24/5/2015 passed in Mise case number 44/2015 was kept in abeyance, is hereby vacated. Oh, yes. The learned counsel appearing on behalf of the petitioner, Mr.
M.
Bolua.
M. Gogoi.
M. Gogoi submits that he has instructions to withdraw the instant petition. Mr. T.R.
Gogoi, Lord.
T.R. Gogoi appears on behalf of the respondents
1 to 7.
1 to 7. So, taking into account the instant petition stands dismissed on withdrawal. The interim order dated 3/3/2016 stands vacated, and the parties are directed to appear before the learned trial court, that is the court of the learned Munsif Sankodev Nagar Hosai, in title suit number 5/2008 on 14th of June 2024. None appears on behalf of the petitioner on call. The records reveal that the petitioner have not appeared before this court since 2021. On various dates. It seems the petitioner is not interested in the instant proceedings for which the instant petition, interested in the instant proceedings. This court also finds it relevant to take note of the affidavit in opposition so filed by the respondent, stating inter alia that there is no violation. Is there any violation?
No, no.
No violation to the orders passed by the learned trial court. Considering the above,
Lordship, there was a delay of 10 minutes.
Okay.
The time given by the court, and the child was he was puking all the way because he comes
considering
all
the
the way
above,
from Shillong.
this court does not find any good grounds for proceeding with the instant contempt proceedings against the respondent. Accordingly, the contempt proceeding stands dropped.
Much obliged.
None appears on behalf of the applicant on call. Let this matter be again listed on 3rd of June 2024. In the circumstance the applicant is not represented, the instant application shall be dismissed for non-prosecution. None appears on behalf of the applicant on call. On 1/5/2024, when the instant matter was listed, the applicants were also not represented on that date. And this court duly observed that if the applicants are not represented, the instant application shall be closed for non-prosecution. Taking into account that the applicant is not represented, how much? 23 days.
23 days.
What to
Last
do?
2 occasions, the appellant,
Who is that lawyer?
D. Swami.
What is wrong with him? What about service also he has not taken?
Service, respondent number 2 had expired, and otherwise the service has been completed.
Who is two?
Specific order was also there in
His wife is there.
wait.
Ratib Ahmed. You are the brother. You are paying for number 3.
I am appearing for respondent 1. Parigoni waiver.
1.
Yeah.
What about 3?
See, the service has been completed, but no one has appeared.
4, 5. Hassan Ali the expired.
Yeah.
They were the plaintiff. Huh?
We were I was the plaintiff. Parigoni. Yeah.
You were the plaintiff.
Yes.
So Hassan Ali was also the plaintiff.
I don't have the appeal memo, Lord, right? I can't put a record.
Hey, file to know. These people not bothered about partition too.
Yes.
See, I dismiss for default, this will come back. Plaintiff web number 2 is Hassan Ali. What is the degree pass?
If he was passed on the way.
Plaintiff suit is dismissed.
Yes. Then we prefer the appeal. And the appellate court remanded back the to the trial.
Against that, this is it.
Against that, they have filed the
How is it maintainable? Where is the appellate court judgment? Yes.
they will use the particular court.
The result, the suit is remanded back to the trial court, and trial court shall consider the therefore if seeking equal. So this will be an appeal under 104. Isn't it? What to do?
Subsequently, they have filed a few other applications also.
But in this case,
Yes.
you got copy?
Yeah, I got the copies for correcting the cost item, for inserting the name illegally of the Hassan Ali.
They have inserted.
No.
They filed an application.
They filed the application in the year 2022 itself.
Those are not on record. I think it's not. Okay. You sure?
Yeah, I've got the certificate.
Who is this D. Goswami?
Devotee.
Huh?
Devotee.
Who is Devojit? Let me send his name to the bar council because of his irresponsibility. I think better off. Absolutely irresponsible. When you take up a matter for the AI, full matters is okay. Mr. A. Dekar, the learning counsel appearing on behalf of the respondent submit that certain applications have been filed by the appellant to substitute the legal representatives of the respondent number 2. Isn't it? Hassan Ali.
Not for substitution, Your Lordship. They
For?
have filed it under Order 6, Rule 17, Review Order 1, Rule 10.
For?
For correcting the name of Hassan Ali.
Okay, some other people have come in.
Yes. As per them, Hassan Ali expired before filing of the appeal. This appeal.
That's an application.
Yes.
Had filed an application under Order 6, Rule 17, read with
Order 1, Rule 10.
Order 1, Rule 10 for making necessary corrections in the memo of appeal, in the interlocutory application as well as memo of appeal. The registry shall verify the same. Do you have the filing? When was it filed?
I don't have the date, but it was filed in the month of January 2023.
The same was filed in the month of January 2023. Yes. Yeah. recollect. It is seen from the office note dated 17/6/2023 that 3 applications have been filed. IAC number 1023/2023, IAC 1021/2023, and IAC 1022/2023. However, the same are lying defective. This court, taking into account the interest of justice and also the fact that the counsel for the appellant, for best reasons known to him, have not chosen to appear before this court consecutive, directs the registry to bring on record the said application so that this court can take up the matter. List the matter again on 31st of May 2024. Yes, what is this?
As per office note dated 25/11.
Some respondent number 3 has expired. What have you done?
Respondent number 1 has not expired, 3 has expired.
That is what I am saying. 3 had expired. What have you done? That was known to you long time back.
We have came to know the last week.
Yeah?
We have come to know in the last week that 1 had not died, 3 had died. Respondent number 3 had died. But in the office note dated, it seems that
Madam,
1 had died.
8/8/2023, there is an office note wherein it says that the learned counsel have not taken steps for substitution of the respondent number 3. Then this court have wrongly passed an order to that effect, but it is actually respondent number 3. The learned counsel appearing on behalf of the applicant seeks for 2 months' time to take appropriate steps.
Maybe the lordship. 30, that's the last order. 30 directed.
Oh, there's one.
Yes, Lord.
Done one. Yes. What happened? Service done.
30 super.
Taken steps upon whether to do that service. Okay. Then we put it up on some other day.
Yes,
Okay.
Lordship.
You are paying for whom?
I'm appearing on behalf of Mr. RTD Chaudhary Lordship. It has been served and insurance corporation we have acknowledged.
Your name, madam?
L. Devi Lordship.
Miss LDB, the learned counsel, puppet, that notice upon the respondent number 1 or respondent number 3. Respondent number 1 have been duly effected. And in that regard, places the documents which are kept on record is marked with the letter that As regards the service upon the respondent number 2 and 3, the petitioner had taken steps by way of blue dirt service.
So, Lordship, because Lordship, the cost of this third service is not bearable by the claimant, Lordship. So much, Lordship, at about 10,000. Lordship, petitioner is not in position to take blue dirt service, Lordship. Both the Lordship, Lordship, post, it's available in the Lordship.
As regards the service upon the response, in view of the document mentioned in view of the contents of the documents kept on record and marked the letter dead, service upon the respondent number 1 is deemed to be complete. As regards the respondent number 2 and 3, the learned counsel appearing on behalf of the petitioner submitted that the cost involved to effect service to blue dirt courier service, it's very expensive, and the petitioner does not have the resources to do so. He therefore submits that the petitioner may be permitted to take steps by way of speed post, which also affects service in the country of Bhutan. Taking into account the above, the petitioner is directed to take steps by way upon the respondent number 2 and 3 by way of speed post. The steps be taken on or before upon the respondent number 2 and 3 on or before 27th of May 2020. It's the matter again on 17th of July.
Value.
Yes. What are you?
My lord, we have challenged the impugned order that may be seen page 39. First, my lord, I want to say some background of the case. A case was by title suit was filed by the petitioner of the present respondent. That lordship may kindly see page 14. Here, I am Habibur Rahman, respondent defendant number 3. So, notice was sent to defendant number 3 and it was hung up. The Darikarak said that nobody was found, it was hung up in that house. I recited.
Wait. How are you filing this appeal? How? First appeal has already been filed.
Already filed.
Then how are you filing this?
That was
Huh?
it filed by the appellant.
How? The order which was passed is.
We have filed this case, my lord. It is under section 104, one of CPC.
Understood. Earlier it was you were challenging an appellate order.
Yes.
Can you challenge an appellate order again by another appellate order?
There is no objection from the side of the registry.
Forget about registry. Kindly see 1042.
It should be RSA in that view, my lord.
No RSC business. Kindly see 1042. Section 1042.
Yes. Order from which appeal lies. 2. No appeal shall lie from any order passed in appeal under this section. That is either 1226 or KP. Either of
115.
115, that is.
You file under 115. It's the learned counsel appearing on behalf of the appellant submits that the appeal has been notified. Taking into account section 142 of the Code of he therefore submits that he is permitted to withdraw the appeal and file and adopt and filed appropriate proceedings challenging the order dated
Order dated 20/20/10/22.
2010-2022 passed in Miss Appeal number 04/2018. Taking into account the above submissions, the instant appeal stands dismissed on withdrawal. However, the petition appellant herein is given the liberty to file an appropriate proceedings challenging the order dated 2010-2022 passed in Miss Appeal number 4/2018. This court further makes it clear that a period of pendency of the instant appeal, that is from Thirteen 12/2022 till date, be excluded while computing the period of limitation. In addition to that, the counsel appearing on behalf of the appellant would be at liberty to file an application before the registry seeking the certified copy of the judge order dated 2010-2022 passed in Miss Appeal number 4/2018. Upon such applications filed by the counsel for the appellant, the registry shall forthwith and not later than 5 days therefrom furnish the certified copy of the order dated 2010-2022 passed in Miss Appeal number 4/2018 to the counsel for the applicant.
There is an interim order.
Huh?
Interim order.
Interim order. Interim order then
My name may be recorded.
I don't reflect anybody, ever reflect anybody. You just give your name, all your names. You can give four names also. Yes, what is this? Section 37.
Okay, this appeal is not maintainable, my lord, because
this
appeal is not maintainable. My lord. There is no final order passed in the section 9. My lord, they have come against the orders stated, my lord. 2 orders were passed and at page 29, and my lord, another is at page 39 and 40. My lord, page 29, notice was issued. Page 29, my lord. 7/9 was fixed for SRN step. And then, my lord, page 39 is the another order wherein, my lord, the direction was given to furnish the copy of the petition to the consequently respondent.
What is happening to that application appeal?
That is pending, my lord.
The petition, the Miss Arbitration
Yes.
case number 45/2023 is pending. Then what remains? Why should we entertain these two?
Objection is also filed, my lord. Subsequent to this order, 7/9 order on, my
You have
lord,
filed objection.
yes, we have.
When is
filed
the next
objection.
date?
Matter was fixed for objection hearing on 6/11, my lord, but due to the pendency of this case, nothing is happening.
6/11. Now there is no date.
6/11/23, my lord. 6/11/23.
Now what is the next date?
Now, my lord, no date is given because of this.
Huh?
Captain abeyance.
Okay. We dispose it of directing the trial court, the
To decide.
court. Is the court.
My lord, it is the court of the additional district judge number 2.
Additional district judge number 2. Okay. Therefore, this is an application appeal under section 37 of the Arbitration and Conciliation Act 1996, challenging the orders dated. How many orders you are challenging?
2 orders.
Orders dated 30/8/2023 and 7/9/2023 passed in Miss Arbitration, Miss R case number 45/2023 by the learned additional district judge number 2, Kamrup Metro at Guwahati. It has been brought to the attention of this court that pursuant to the orders being passed on 7/9/2023, the respondents have duly appeared before the learned court below. Learned court wherein the section 9 proceedings have been initiated and also filed their written objections. Under such circumstances, this court is of the opinion that the continuance of these two parallel proceedings is not warranted. It has also been brought to the attention of this court that the hearing of the said arbitration case number 45/2023 has been kept in abeyance in view of the pendency of the instant appeal. Accordingly, this court disposes of the instant appeal, thereby directing the learned Additional District Judge number 2, Kamrup Metro at Guwahati to dispose of the said arbitration case number 45/2023 within as expeditiously as possible. Taking into account that there is a abeyance by the court itself in view of the pendency of the instant proceedings, this court directs the parties to appear before the learned Additional District Judge number 2, Kamrup Metro at Guwahati on 27th of May 2024. On that day, the learned court of the Additional District Judge number 2, Kamrup Metro at Guwahati shall pass appropriate or fix the matter for hearing and shall dispose of the same proceedings, preferably within 3 months. With the above, the instant appeal stands disposed, I stands closed. Yes. What you are challenging?
Pardon?
What are you challenging?
Your Lordship, the order passed by the Learned Civic Judge 1, Civic Judge 2, order dated 23 to 50. Sorry.
Yes, what order? He doesn't know.
123, Your Honor, passed in
25, page.
Page 14, Your Honor.
Huh? Page
14. Impugn order dated
page 14. 25/1/2020. Injunction granted. What is that? In view of that, I have heard long injunction is accordingly disposed of with So what is wrong with the order?
My lord, actually, even we are entitled to the assisted property that is.
You'll get the property when you win the case. When you win the case, you'll get the property.
Your Honor, by the time the construction is almost completed, Your Honor, when we started with the construction.
You break the property. You'll break it. If you lose the case, you'll break the property.
Yes.
Isn't it?
Yes.
You give an undertaking.
Your Honor, if the Lordship is they give an undertaking, then it's okay. But Your
No,
Honor,
no, they have to give an undertaking. If they lose the property, that is the order passed. You have that is the order passed. You are trying to protect that order. That if you lose the case, you are going to break the property. Who are you?
I'm paying for a respondent.
No, it's okay. Sole respondent. Who are you? Why are you constructing? Prannoy Jyoti Deka. Who are they? Proprietor of Satyanaran Builders. Okay. We'll have it on some other day. You give an undertaking as to whether you are going to demolish the property if you lose the case. We're not going to state. List the matter on this court upon hearing the matter is have sought for instructions from the respondents as to whether the respondents who demolish the property to construct it if the suit is decided against the respondents. Leaves the matter again on 25/2024. On which date an affidavit be filed by the respondents.
I
know.
Why the LCR has been called? LCR is the name. LCR, no? तो ऐसे नहीं कुछ ठीक है you are challenging what order?
My lord, at page 51, Lord, to be fine. My lord, we prayed for an injunction, my lord, that has not been granted. My lord.
Then why you are calling for the records?
Because, my lord, before filing the petition under order 39.
Which order you are challenging?
My lord, at page 51 of the appeal.
So, I've heard the learning council at this stage, I think it proper to issue notice. So against that, the entire proceedings have been stayed from 21/6. There's no order.
No, my lord.
Have you got any injunction?
Not there, my lord. Here we got an order of status quo, my lord.
Till returnable date, both sides are directed to maintain status quo in respect to the suit property. They say no construction shall be undertaken by any of the parties. Yes. What do you have to say?
No construction was going on, my lord.
Interest.
And we have
Status
not
quo.
agreed that.
Maintain the status quo till the disposal of that application. It will record to Ghuraidival. This is an application.
Now I am appearing to only respondent one.
This is an,
Only for one.
Not yet been served.
Understood. Who is the main person?
Land belongs to us. Respondent number 1 and 2. They tried to occupy 3 kathas of land. So they were made parties in the LP case.
Have they appeared there?
No.
No, my lord. They are also respondent number 2 has not been served. One got notice. But he has not responded to the notice of the court.
Why you have not been able to serve the respondent number 2?
Well, he decides there as per to my instruction, my lord.
Huh?
He decides there only, my lord. The address is correct and I am not able to.
Lord, may kindly have page 13.
Where is
He
the
is
respondent number
residing there,
2?
my lord.
Well, the Pandu, my lord.
Then why you are not able to serve him?
Same address is same, my lord.
Huh? Why you are not able to serve him?
But we have taken steps, my lord. I don't know, my lord.
If you don't serve him, then why should we? The record reveals that the service upon the respondent number 2 is not complete.
Permitted, my lord. Trustee permitted.
The Learned Counsel for the appellant submits that he may be permitted to take steps by way of dusty upon the respondent number 2. Lists the matter again on 10th of June 2024. Steps be taken by way of dusty upon the respondent number 2. Routed to the registry of this court and file an affidavit of service on or before the next date. Let it be on 17th of June, huh? 17th of Footstop. This court further is of the opinion that the LCR is not required, for which the registry is directed to forthwith return the LCR to the court below. Footstop. However, a photocopy of the LCR be maintained in the records. Footstop. I cannot be up. Econ Diop, that's 7/8/2023. The interim order passed earlier shall continue till the next date, that is 17/6/2015.
Public.
Huh? Which? You have not taken service steps by heir detaining. You're not interested. You want to withdraw? Miss, what's your name?
RHIP.
The learned counsel appearing on behalf of the appellant submits that the appellant does not want to proceed with the instant application appeal. Accordingly, the instant appeal stands closed on withdrawal. Yes, you are filing a reply.
Yeah, we have filed the reply.
You
And
filed it.
we have already filed. I believe it's been tagged and it's also
It has
been
not been
served.
received here.
We had
The learned
information.
counsel appearing on behalf of the appellant.
It was always also
Respond
been
number
served
1 submits that the reply has been filed on
last week actually.
in the week commencing from 6th of May 2024. List the matter after 2 weeks. There's no interim order.
That's the case.
List the matter after 2 weeks. By enclosing, by bringing on record the said affidavit. What is this order time?
A date may be given because it's been served also.
Huh?
And it was we have the information that it was also tagged. But somehow
Okay. List the matter again on 27th of May. Yes, you are appearing.
My lord.
All the respondents.
1, 2 and 3, my lord.
Huh?
1, 2 and 3, my lord.
How many respondents are there?
My lord, we have taken the service prior service upon the respondents 4, 5, 6, and 7.
You have taken. Service is complete.
Service complete. An affidavit has been also filed compliance of the order dated 19/6/23.
Affidavit regarding compliance. Let's see the affidavit. That in terms with the and clearly of the client will return to the respondent of back. Where is the receipt? Huh? Whose signature are these? This is not type of affidavit you file like this. Who has filed it? Mr. Counsel, this is not a type of affidavit. How will you know that this is whose signature? Is it the signature? Tell me. You have a copy of the affidavit?
Yes.
I'll see page 16. Whose affidavit signature? Page 15. Can you tell me?
Red one. Red one.
Can you tell me whose signatures are these? This court have duly taken note of the affidavit of service so filed. The said affidavit in service does not mention as to whose signatures appear in Annexure 1, 2, and 3. So, taking into account the above, the petitioner herein is directed to file a fresh affidavit of service. This is the matter of the 2 weeks.
Okay.
Connected this applicant ID for observation of
How much
delay of
delay?
91 days.
Huh?
91. I repeated the paragraph 60.
Why the delay? Again, section 34. Huh?
Again, section 32. I have put it.
Okay. Why the delay?
If you are suffering from back pain and after at the type of during
giving an order dated 28/5/2018, was earlier passed by the not commissioner.
Now, the Supreme Court recently changed it, no, the earlier. Your appeal has been dismissed. 34 has been dismissed.
They preferred the that is,
Huh?
it has been preferred by the National Highway Authority.
National?
National Highway Authority. Their
Okay.
appeal has been.
I hope this is an application under Section 5 of the Limitation Act for condoning the delay of 84 days in preparing the appeal under Section 37 of the Arbitration and Conciliation Act against the judgment dated 7/12/2022 passed in Miss Arbitration case number 02/2022 by the learned district judge Ponipur. This court have duly taken the grounds stated in the said application and have also perused the grounds stated in the said application to explain the delay in preparing the accompanying appeal. The grounds which have been mentioned in paragraph number 18 to mentioned in paragraph number 15 to 21 in the opinion of this court are sufficient, constitutes a sufficient cause for condoning the delay of 89 days. 89 days, huh? 84 days. 84 days. According the delay of 84 days in filing the accompanying appeal stands condoned. It's the matter for the accompanying appeal be registered and listed for admission in due course. In listed for admission in the last week of May.
With your lordship, and kindly see the office note dated 9/5/2024. The notice has come unserved. The family member of the respondent have refused to receive. And even the dusty survey, we could not serve properly. He has refused to receive.
Can you file an affidavit to that effect? That we went out there, he has refused to receive, so then we'll pass an order. From the office note dated 9/5/2024, the service upon the respondent is yet to complete. Taking into account the above, this court fixes the matter again on 15th of July 2024. Petitioner is yet again granted, the applicant is yet again granted the liberty to file, granted the evidence. It is yet again directed to take steps by way of registered post along with AD upon the respondent, and also to take steps by way of the C routed to the registry of the court and file an affidavit of service on or before the next stage.
Your lordship, kindly we may be permitted to take steps to the nearest police station. To the nearest police station.
By police. Bye.
There are no chances of prosecution.
Let me go to the criminal bench, then I'm in the civil bench. Oh, God. Yes. What about the service? You have not filed the affidavit of trustee?
Today we have filed the affidavit of trustee.
Ms. So the learned counsel appearing on behalf of the petitioner submits that the affidavit of trustee has been filed during the course of the day. This is the matter again on 28th of May 20.
Interim passed earlier.
We listed again on 25, 2024. So the interim order passed earlier shall continue. The registry shall bring on record the affidavit.
This is your lordship. Perusal of the last order dated 5/4/24. We have taken both steps, your lordship, by registered post with AD card, your lordship, service completed, and also dusty service. Although dusty service could not be completed, your lordship, for that we have filed our affidavit on dated 6/5/24. But respondent to your lordship registered post, your lordship, service completed. They have made appearance, your lordship, by filing their affidavit.
This court have duly taken note of the affidavit of service so filed by the
I'm appearing for this.
appellant. You are appearing?
Yeah, I'm appearing.
Your lordship, registered post, your lordship, we have taken both steps. Your lordship.
He is appearing.
Yes, your lordship, service
Now
completed.
tell me. What is that? What you want to transfer from where to where?
Your lordship, from family court, your lordship, Guwahati, your lordship, to original jurisdiction where DP case is going on, your lordship. It is still pending. DP case is still pending.
From Guwahati to Nagaon?
Yes, your lordship.
Where
Where
do you
original
stay?
jurisdiction is going.
Where do you stay? In Nagaon?
Nagaon.
And you stay
In Guwahati, my lord, Chandrapur.
Huh?
Chandrapur, Guwahati.
Chandrapur?
Yes.
Oh, go to Nagaon.
My lord, he
Chandrapur
has
is
filed a
nearby.
restitution of conjugal rights, my lord. He is
Huh?
ready to take her back, my lord. He is ready
Your
to
lord-
take her back, my lord. He is not coming, my lord.
Your lordship,
Husband is ready to take her.
he waited outside of his house, your lordship, while
That is why he
serving
has
your
filed.
lordship dusty service, and by using foul language.
He wants
your
to
lordship.
go. He says that he wants to take you back.
That
lordship,
is why he has filed restitution of
That is
conjugal rights, my lord.
why your lordship, he has
Not
filed
divorce.
restitution, your lordship. Kindly, that
Who has
has,
filed the receipt?
I have filed, my lord.
He has filed the receipt.
That
yes,
is
your
why I have
lordship.
filed, my lord.
Yes, your lordship.
You don't want to go.
So, your lordship, pertaining to that, your lordship, restitution petition, let that petition is transferred to original jurisdiction where DB case is going on.
Why are you going further with DVK? DVK is for small court. This is a restitution is for bigger.
But she is having trouble, your lordship.
What is the trouble?
She is like having 3.5 years old child, your lordship.
Okay.
And she
Give the
is,
child to the father. The father will be happy, no?
My lord.
The father will be happy with the child?
Yes.
Yes.
no, your lordship,
Give
because,
it to her.
no, your lordship, because,
Yeah.
because
he is
till
willing to
date,
Your
because
problem is the child. The mother should be more saying that I have a boon, the child is with me. And you are saying you have the child is a headache?
no,
My
your lordship,
goodness,
she
madam.
is having that daughter is having, your lordship, a urinal infection, your lordship. That's why
That's
she
not
cannot.
permanent, madam.
Yes,
That
your
cannot be a
lordship.
ground for
Yes,
transfer.
your lordship. But your lordship, there are some judgment also,
Oh,
your
judgments
lordship,
are
where
there.
wife
Madam,
convenience
if you are
convenience
showing
must be
judgment,
seen, your lordship.
Madam, if you showing judgment, better go to Supreme Court. Judgments are there, not here.
Your lordship, my only prayer is, your lordship, since already made communication, your lordship, by perusing, your lordship, earlier order dated, your lordship, but she is refusing to come to Guwahati, your lordship. She is praying that kindly this matter may transfer to Nagaon, your lordship, for her convenience, your lordship.
What is the convenience? What is the difficulty? What does she do?
She does nothing, your lordship, and your lordship.
That is why she her husband wants to take her back. Then filing a DV case out. What is the DV case for? You are already getting maintenance.
Your lordship,
10,000
earlier-
plus 2,000.
No, your lordship, only 2,000 is given, your lordship. That to many occasion he did not give your lordship.
For a daughter and child, it is given. Please to grant, and you are getting the money.
3,000 is what done.
And
I
most
will
also
allow to
accept
get
the amount of 3,000
original
received by
documents, your
her.
lordship,
That is in the month
indicating
of
that,
year
your lordship.
following month.
He is not paid monthly basis, your lordship.
What do you do?
I'm a contractual employee, my lord.
Huh?
Contractual employee, my lord. 10,000 I am getting salary.
See?
He is doing in electricity.
Both get employee, my lord. Contractual that is one. Not permanent.
You
It's a
shouldn't
salary
keep on,
is
and
what
he
I
is
have.
filing litigation. What to do?
That's why he's ready to take on.
I'm praying, your lordship, kindly this restitution petition may transfer to original jurisdiction.
Why?
No, your lordship, since she is having problem, your lordship, she is refusing to come, and he is also not paying it monthly basis, your lordship. The maintenance.
You do one thing. Well, let me transfer it to Naga. You don't pay that amount. Stop paying that. Because here, if I give, I'll have to ask you to pay. So better let me transfer it. Let it be transferred. Don't pay her any single penny. I think that is a better course. You say that you are a contractual employee.
Yes, I have already submitted before the court.
Yeah.
10,000 salary.
Chalo. Transfer kori dibo. Transfer kori dibo. Prepare kori le transfer kori dibo and make it by appearance of the her. Both the parties shall appear on 24th of June before the district judge Nagaon. Our principal area put 24th of June hobo ne? Let it be on 1st of July. 1st of July. Yeah. Record to tapa ya pata. On that day, she will file her written statement without fail.
Deeply okay.
Yes, what is this?
My lord, the contempt of the order dated 4/2020 passed by this honorable court, my lord.
Where is the respondent?
Respondent, they filed the affidavit.
Huh?
But none has appeared.
What is the order you are referring to?
That, my lord, your lord will find a TT and the operative.
Okay, we'll have it on some other day without the lawyer or the admitted
At
fact for
page
bringing
11,
goods from West Bengal.
cooperative-
What are you challenging? Is directed to hand over the consignment which they have brought from West Bengal to Guwahati and meant to be delivered to Sri Spanish. Consignment shall be handed over to them. Yes, I heard about this matter. That matter.
Yes.
Appeal keeps on going on.
Yes.
You are filing.
Yes.
Your entire relief is this.
Yes.
You got it in the interim itself.
No, now.
That is the final relief.
Yes, final.
How is it being given? That's the final relief given. Isn't it? In the suit, this is the final relief.
But they also filed the counterclaim. The counterclaim is pending.
Hello. Taking into account that the respondent is not represented today, matters can be adjourned to be listed again on 5th of June 2024. It is made clear if the respondent is not represented on the next day, the instant court, the court shall proceed on the basis of the material.
My lord, that is some idea.
5th of June. Yes, what is this LCR received?
Matter that is the matter where I was not paid party. My
Huh?
I was not paid part, so I have filed one IA for impleadment. That matter, Lordship, in the RSA was filed against the order of the first appellate court. First appeal was preferred by the defendant. Right?
And you are? Oh, that matter.
In the RSA, the main defendant.
Where's the other matter? Oh, the matter is not
No,
there.
this is the.
Oh,
In
you
RSA,
want, you withdraw this.
Sure.
Better off. Don't keep this because this is nothing to do.
Lordship, I have taken consent from my client to withdraw, but Lordship, in the meantime, the client is still possessed, Lordship, by the plaintiff. So he again filed a case for the London Trial Court, title 226 of the 2020. And in that petition, I have seen that he has mentioned about this.
Okay. We make it clear
Sure.
that the withdrawal of this application shall not affect the suit.
Sure. And one more thing, Lordship, I'm not aware that evidence was died for part. From this document, I came to know that Amir Ali is the main party. So when I asked what about Rabia, then in 2 years Rabia died. So I have filed this IA also on a dead person.
This one. It's okay. Miss R. Chaudhary, the learned counsel appearing on behalf of the applicant submits that she has instructions to withdraw the instant application. Taking into account that the applicant was not made a party in the trial court.
In the regular
Earlier you were there.
I'm the main defendant number 1. I have filed my written statement, then football 6. Then I have filed the first appeal.
Submits that she would not like to press the instant application. Taking into account that the instant appeal has not been filed against the applicant who was the main defendant. This court is also of the opinion that if the appellant in RSA number 355/2017 have not impleaded, the main defendant number 1, the appellant may have foregone his right, their right there, na? One. Is her right to challenge the appellate decree, judgment and decree, insofar as the defendant number 1.
It was filed by defendant number 1.
No, it's okay. Because that has merged. Taking into account the above, the instant application stands closed. Have foregone the right, have foregone, and as such, the judgment and decree passed in title amendment number 67/2013, insofar as the defendant number 1, who was the appellant, had attained finally. Consequently, as the learned counsel appearing on behalf of the applicant submits that she would like to withdraw, the instant application stands withdrawn. The withdrawal of the instant application shall not prejudice the rights of the applicant in a suit subsequently filed, being title suit number
26/2022.
26/2022. Then why did you file in 2024 this? How can I say that? Let us not mention that, because you may not have mentioned about this application.
No, Lordship, that was a petition was filed by the plaintiff. He is the plaintiff in this title. That was for right interest and covered the post. He stated that that it came at the knowledge of the plaintiff that the predecessor in interest of the defendant number 1 to 4 filed a case number RSS 350.
No. Did you file an IA? Did you mention that?
No, I have not.
So not necessary about it. You'll explain to Nalak. Which are moving on.
Are they evidence from last occasion from this court that they have returned the brief to the bank?
It's okay. List the RSA on 27th of May 2024. We will take it up on that day because the judgment against the appellant, Qasim Ali, is not, the Qasim Ali is not a party here. And as such, we will dismiss the appeal.
But not maintainable.
Yeah. The appeal is not maintainable with the Qasim Ali.
Because the title of it was filed by only captain.
That's good.
Obliged.
I extend it. Or madam, we do one thing. We don't mention so much. We say that you want to withdraw, we'll withdraw. Means that she wants to withdraw the
That
instant
it may
application.
clarify.
Huh?
If you're not mentioned, that it may clarify.
Yes.
Otherwise,
It will
later.
wrap up time. Let me. What are the first time? Notice 6 weeks.
There are three applications. Sir. There are three applications.
Notice 6 weeks. Steps by way of registered as we. $45, $46. So same, huh? 45 also first time, na?
Yes, Your Lordship, there is a high in delay condonation petition is there.
So notice has to go. Notice 4 weeks.
Your Lordship, when the RSA was filed, at that time notice was not served.
Huh?
Notice was not served at that time when it was dismissed, not admitted. It was dismissed due to non-prosecution, Your Lordship. On
IA for what?
for delay condonation.
How can I condone delay without notice? I can't do that, na? Now if I 45. No. Notices to go. Both the notices. Both it. Huh? 6 weeks. Steps by reach. What are these? Delay. Substitution.
Well, at the last case, the court is direct by your colleague, party the legal heir of Kurubala.
Yeah.
Pilot, now he said that he is alive. So if he is alive, pilot, I have nothing to say. I like to do the petition, my lord.
Is it alive? See? Who informed you he's dead?
No. There is some misunderstanding. I have not stated that he is dead.
Who? Regarding whom?
Respondent number 11. 11.
Respondent number 11 is alive.
Yes.
So all these IAs are for him.
No. 1120 of 2024. And my lord, in another case, 1124 in RS. I filed this IA, my lord, directly to party the legal heir. So I filed this petition directly to party the legal heir.
What are the other IAs for?
No.
These
IAs
IAs were mentioned. These were for substitution, not substitution, but condonation of limitation. Already disposed of.
These are disposed of. No, all these 2018.
Oh, my lord, that is regarding the Tasco. That make kindly be disposed
Wait,
of.
wait,
The
wait,
last
wait,
order
wait,
was
wait.
there.
Order 22 as regards appellant number 5. That has been done.
Order.
22.
Appellant number 5 only.
Narayan.
Appellate number 5, my lord, from the record I have seen, my lord, the limitation has been condoned. But so far ISC 2439 2020 is concerned. That is
So
for
this is
substitution
defend
of
number 4.
appellate number 5.
Respondent number 4.
Not yet legal heir has not been substituted.
So here notice is to go. Notice has been issued.
Well, he received the copy, my lord.
You have appeared.
He filed.
Anyway, first let us take up case of 1123
Yes.
and 1120.
Yes. Second case.
Let us first complete that. Okay. These two applications were filed on account of a misunderstanding amongst the councils as to the date of the respondent number 11. Mr. R.K. Jain, the learned counsel, appearing on behalf of respondent number 11, today submits that the respondent number 11 is duly alive, and in that regard have placed, respondent number 11 is Parul Pal, have placed a certificate issued by the Gaon Pandar, Nagaon, Lalung Nagaon. The same is kept on record and marked with the letter X. Taking into account the above, both the applications being IAC 1123/2024 and IAC 1120/2024 have become infructuous and accordingly stands closed. 385 Goodite, respondent number 4. Respondent number 4, you have filed objection?
Yes.
Respondent number 4.
Narayan Pal.
Nowadays, what I do, therefore, all these small label, this what is this again? I-1 seeking permission for construction of the lavatory.
It
Oh,
has
this
been
one.
disposed of.
This has been
Lordship
disposed
disposed
of.
that.
I can dispose of. Then they can dispose of. Able to dispose of. I would dispose it. Now this is order 22 rule 4.
Well, so far ISC
This is
number-
filed within time.
No. As per his information, my lord, I filed it.
When?
Well, that matter will be taken up by another.
How much delay?
It may, my lord, in 309 and 306, my lord. Same petition, my lord, regarding
602 days.
substitution of my lord ready.
602.
Respondent number 4, my lord.
Okay. In respect to the others, kono beleg eta order kori dibo. The county kono TTP.
Regarding ISC number 4028 of 18.
Yeah. Deal kori kon. Ikono eta order is the matter. Number 4. Four is Tipra Banik. Who is respondent number 4?
Narayan
Pal.
Narayan Pal died when?
18/12/2017.
And he filed his application on 7/10. And you informed when?
I have not been informed.
How did they come to know?
I can't say. I
Because
can't say.
as per his information, I am substituting
No.
the respondents, my lord.
No.
Otherwise,
List these matters again on, let it be on 10th of June.
It is the only passing of bucket.
Huh?
It is only passing of bucket.
Yes, what is this?
That is a lot. My lord, in the morning I made a mention, my lord. And it's ordered 24/4/2020.
But there is an injunction. Yes, what?
My lord, our objection is ready, my lord, because of disruption of road communication, my lord. Petitioner could not come, my lord. He from Oracle.
You are filing when?
Within 10 days, my lord.
AMR.
AHMR.
AHMR. The Learned Counsel appearing on behalf of AHMR Chaudhary, the Learned Counsel appearing on behalf of the respondent. 10 days time for filing objection to the instant application for instant application. List the matter again on 12th of June 2024. 12th of June?
After
13th, 14th?
on 12th at 14th.
Okay, before 10th of June? On 10th of June 2024. The injunction order passed on 24/4/2024 shall continue till the next. Yes, anything? You should have mentioned this matter. The Parthard matter should have come up. Tell me. Anything happened?
My lord, the authorities are seeking some time, my lord, in view of the elections, my lord, model code of conduct going on.
Model code of conduct, what are the, as of now, they have no business. Now there's no work. It is more time.
So time, my lord, but my lord, they will have to, my lord, give reports on daily basis to the government.
For what?
My lord, for with regard to strong room and all other, my lord, administrative, my lord, that is the difficulty.
So?
So they are seeking some time, my lord. Under these circumstances, I am praying, my lord, for fixing this matter. My lord, perhaps, my lord, in the second week or third week of June, my lord. By that time, my lord, affidavit. Because we are only required to file an affidavit, comprehensive affidavit, bringing on record, my lord, what had transpired in the consensual meeting as per my lord's direction, as well as on a general, my lord, on a my lord, the inputs on the overall matter, my lord. This is how present status of the land and all these things. We have duly communicated, we have instructed, my lord. I am following up the on overall, my lord, almost, my lord, every week, day-to-day basis. In fact, today morning, I had a talk with the additional deputy commissioner, my lord. They say, my lord, this is the only difficulty. Otherwise, my lord, they have already deputed their subordinate officials, my lord, to prepare the, my lord, the instructions for filing the affidavit. Only to the limited extent, my lord.
Mr. Arbopoulos, the Learned Counsel appearing on behalf of the Revenue and Disaster Management Department submits that on account of the ongoing election process, some more time may be given as the district administration is busy with the electioning work. This the matter again on 17th of June 2020. And I will have it on 18th of June.
My lord.
18th of June
I'm so obliged.
2020.
I'm so obliged.
Pick it up at the top.
It's the
Yes,
the
top of
matter
the
be list shown as partnered and shown and be taken up, could be taken up at the top of the list. These matters should be mentioned.
Lordship is maintaining a regular correspondence with us not to disturb my lord in between.
Which one? No, you see, these type of matters, it's because it's a partner matter. I know about this matter, so it could have been over by that time. I therefore give, like today, there was one personal appearance, not personal, I asked them to be there. This was a case where the earlier counsel out there misled this court and gave an undertaking, state that only 50,000 was to be paid. I said only 50,000 was to be paid. There's an old widow lady in the MSCT, why you are not paying? So they said, we are going to pay. Okay, pay that. And within fixing a date, you pay them. Then after that, I dispose it off. After a few days, it comes to light that the amount is around 6 lakh, not 50,000. Then they file a review. Then that is why I'm keeping it pending, that let it till the entire amount is not liquidated.